Good evening, members. Myself, C. Raj Chawla. Welcome you all in this our Webathon 2. Today, we are organizing the webinar on succession planning and inheritance law part 2. And the topics which our guest speaker will cover: discussion on succession law for Hindus and others, discussion on law relating to ancestral property, HUF property, and self-acquired property, inheritance, post 2005 amendment, discussion on execution of a will as an important tool of succession planning, discussion on formation of private family trust to ring fence for property from creditors and also succession planning, concept of living trust, international trust, or wealth creating and generation benefit in transfer pricing and related party disclosures, discussion on succession of large and mid-sized family run business and succession of professional CA in practice. And we are very honored to have with us CA Vinod Jain ji, our past Central Council member and very renowned chartered accountant, with us as a guest speaker, and also Advocate Abhilash. Welcome, Jain Saab and Abhilash. We are also very honored to have with us our panelist Shashi Chattaji, our ex-chairman Panipat branch. Welcome, Chattaji. And I also welcome CA Sunil Garji, my friend
Thank you.
and the moderator of this webinar. So now I request CA Sunil Garji to please start this webinar.
Thank you, Rajji. First of all, I welcome very honored Honorable Sri Vinod Jain ji, ex-CC member, and his young team, including Astha Jain, Ananya, Advocate Akhilesh, and Chavi Jain. And I also welcome special guest from Panipat, my elder brother Sri Shashi Chadda ji, who has joined us today. So, friends, as you know, this is Webathon 2.0. And as promised by us, we will be having a detailed discussion on the Hindu Succession Act, succession, interstate successions, then private trust, wills, HUF, business reorganizations. And I'm pleased to inform you also that Shri Jain Saab has accepted our request that to take one more session on 19th of this March so that we can have detailed discussion on these topics. As you know, friends, succession planning is a very hot topic today. In the last webinar, we did this Hindu Succession Act. हिंदू सक्सेशन एक्ट की बात की थी हमने. आज हम उसको पहले कंप्लीट करेंगे जैन साहब. और एज यू नो हमारे यहाँ पर सक्सेशन को लेकर, मैरिज को लेकर पर्सनल लॉज भी हैं. तो मुस्लिम्स की सक्सेशन अलग होती है, हिंदू की हिंदू सक्सेशन एक्ट में होती है. लेकिन जहाँ पर इंडियन सक्सेशन एक्ट लगता है वहाँ पर पर्सनल लॉ नहीं लगते, इफ आई एम नॉट रॉन्ग. सेकंड इशू HUF प्रॉपर्टी को लेकर रहता है हमेशा. जैसे बताया था कि 2005 के बाद में एक बहुत बड़ा चेंज आया. अब डॉटर्स आर द को पार्टनर्स, उनके क्या मायने हैं, उससे क्या मतलब निकलते हैं. और एक बात और जो आज जो सर 2 सेशन में बताएंगे जैन साहब, कि इनकम ट्रांसफर और वेल्थ ट्रांसफर में क्या फ़र्क होता है. हम लोग इनकम क्रिएट करते हैं, हम इनकम कमाते हैं टू क्रिएट वेल्थ. But how to transfer that wealth from generation to generation in the safe hands, that is very, very important. Similarly, private trust को लेकर हमेशा बहुत इश्यूज रहते हैं, बहुत ज़्यादा इशू रहते हैं. और सबसे बड़ा इशू जैन साहब जो लोगों को लगता है, प्राइवेट ट्रस्ट इज अ वेरी गुड स्ट्रक्चर एज फार टैक्सेशन इज कंसर्न. जैसे सर ने बताया था पिछली बार भी कि जब आप प्राइवेट ट्रस्ट सेट करते हैं तो सेक्शन 47 में ट्रांसफर नहीं माना जाता. सेक्शन 56 में अगर आप प्राइवेट ट्रस्ट रिलेटिव के नाम पे सेट कर रहे हैं तो 56(2)(10 नहीं लगेगा. और जहाँ तक इनकम, और जब वो डिजोल्व भी होती है, क्योंकि बेनिफिशियरी की इनकम होती है, बेनिफिशियरी का सेट होती है, तो उस टाइम भी ट्रांसफर नहीं होता है. सिमिलरली व्हेन इनकम इज कंसर्न, अगर इनकम की हम बात करें तो 161 कैपिटल ए में अगर आपकी स्पेसिफिक ट्रस्ट है तो इट हैज टू बी टैक्स्ड टू द सेम मैनर, टू द सेम एक्सटेंट एज ऑफ द सेटलर. यानी बेनिफिशियरी जहाँ डिसाइडेड है वो बेनिफिशियरी की इनकम ही होती है. 164(2) में अगर डिस्कसी ट्रस्ट है तो ऑफ कोर्स MMR का टैक्स लगता है. कुछ स्पेसिफिक केस है जहां पर टैक्स स्लैब रेट पे लगता है. लेकिन मैं आज सर से रिक्वेस्ट की थी, सर जब प्राइवेट ट्रस्ट ले तो ऑफशोर ट्रस्ट, पनामा लीक्स आपने सुने होंगे, बहुत हल्ला हुआ था, बहुत सारे लोग ट्रस्ट सेट करते हैं, ऑफशोर ट्रस्ट बनाते हैं, और ऑफशोर ट्रस्ट से पैसा फिर घूम के पी नोट्स के जरिए काफ़ी उसमें ट्रांजेक्शन होती हैं। कैसे वो वेल्थ भी क्रिएट होती है, नहीं होती, या पीएमएलए के या बाकी ब्लैक मनी एक्ट का उसमें क्या इफेक्ट आएगा, बड़ा इंटरप्ले है उसमें। मेरे हिसाब से इससे टेक्निकल सब्जेक्ट, और इसीलिए हमने जैन साहब से रिक्वेस्ट की थी कि इसको हैंडल करना, इस सब्जेक्ट को, इस टॉपिक को। मतलब मैं तो समझ नहीं पाया, 2-3 बार मैं सेशन ले चुका हूँ। और तीसरी बात सर, जो जो लोग हमेशा कंफ्यूज रहते हैं, और जो जो मुझे भी लगता है कि जब प्राइवेट ट्रस्ट आप सेट कर रहे हैं तो इमूवेबल प्रॉपर्टी अगर आप देंगे, इमूवेबल प्रॉपर्टी, तो ऑफ कोर्स स्टैम्प ड्यूटी पिक्चर में आएगी या नहीं आएगी। आप जब प्राइवेट ट्रस्ट को सेट कर रहे हैं तब स्टैम्प ड्यूटी लगेगी, नहीं लगेगी? और जब प्राइवेट ट्रस्ट से वो बेनिफिशियरी के नाम प्रॉपर्टी जाएगी, फिर क्या स्टैम्प ड्यूटी लगेगी, नहीं लगेगी? इनकम टैक्स तो समझ में आता है, पर स्टैम्प ड्यूटी का इशू बहुत बड़ा है, क्योंकि आज सर्कल रेट बहुत ज्यादा है। तो और नेक्स्ट सेशन में हम बात करेंगे बिजनेस रिस्ट्रक्चरिंग की, बिजनेस रीऑर्गेनाइजेशन की। तो इट इज गोइंग टू बी अ वेरी इंटरेस्टिंग सर, वेरी इंटरेस्टिंग सेशन, और आई एम गेटिंग अ लॉट ऑफ फीड फ्रॉम थ्रू आउट द इंडिया सर, एंड पीपल्स आर वेरी हैप्पी. So with these words, now I hand over the mic again to Mavia or Dr. Raj Chawla ji to invite to further the proceedings of this webinar. Thank you.
Thank you, Sunil sir. Now we are very honored to have Shashikant Chadda ji in today's panel. He is the past president of Panipat Chartered Accountants Association for 2 different tenures. Setting up of Panipat branch was also in his tenure as a chapter president. He was also the chairman of Haryana Chamber of Commerce and Industry, Panipat for 2012 and 2014, and general secretary of HCCI Haryana State for 2 years. He was also vice president of Panipat Sales Bar Association in 2001 and 2, and also he was the president of District Panipat Badminton Association. I welcome you, sir, and request to say a few words on the topic. I think we lost connection with him. He's not on the panel right now.
बात करिए एक बार.
Yeah. Yes.
हाँ, शशि जी से एक बार बात कर लीजिए. अच्छा सर, जो 2-3 फीडबैक और आए हैं सर, मैं वो भी प्रेजेंट कर देता हूँ सर.
मैं सब नोट कर रहा हूँ, बताइए प्लीज.
हाँ सर, थैंक यू सर. एक सर लोग ये पूछ रहे हैं जैन साहब कि मान लीजिए प्राइवेट ट्रस्ट में अगर हम शेयर्स ट्रांसफर कर देते हैं, शेयर्स होल्डिंग, तो इज इट ए गुड प्लानिंग? सर चड्डा साहब आ गए हैं. मतलब प्राइवेट कंपनी को रिस्ट्रक्चर करना हो तो बजाय बच्चों को देने से, मतलब बहुत सारे लोग सोचते हैं कि मैं अगर प्राइवेट ट्रस्ट पे डाल देता हूँ, क्योंकि डिविडेंड पे भी कैप कर दिया, अब तो 15% कर दिया है सरचार्ज, तो क्या वो एक प्लानिंग हो सकती है? ऑफ कोर्स यू आर कवरिंग दैट आल्सो. नाउ सर, चड्डा जी हैज जॉइंड सर. प्लीज चड्डा जी से फ्यू वर्ड्स अबाउट टुडे टॉपिक सर.
थैंक यू सुनील जी. आज का सबसे पहले तो मैं थैंक्स करना चाहूंगा राज चावला जी, जो इतना बढ़िया प्रोग्राम चला रहे हैं, सीरीज चला रहे हैं, और हमारे बीच में विनोद जी गेस्ट स्पीकर. तो ये इशू से हमें, जब से हम प्रोफेशन में आए तब से हम विनोद जी को सुन रहे हैं. पानीपत में जब मैं ब्रांच चेयरमैन या उससे पहले एसोसिएशन प्रेसिडेंट था, तो कई बार विनोद जी को हमने बुलाया, तो बड़ा अच्छा लगता है कि कुछ सीखने को मिलता है. और स्पेशली आज के टाइम में ये जो टॉपिक है, जब हम करते थे थ्योरेटिकल, जब हम क्वालीफाई कर रहे थे, तो ये टॉपिक बड़ा इंपॉर्टेंट होता था थ्योरेटिकल पर्पस के लिए, या उस टाइम पे हम छोटी मोटी प्लानिंग किया करते थे. लेकिन जैसे अब पानीपत हम छोटे शहर में हैं, तो लगता है कि बीच में हम ट्रेडिशनल प्रैक्टिस में आ गए थे, और इस सब स्कोप ही नहीं.
I think again we lost the connection with Shashi ji. Avia?
Sir, I think there must be some connection issues.
So can we request Jain Saab to start the webinar, and we can have his words in the last.
Yes, sir.
सर बीच में भी
Please.
करा लेंगे. Once he
हाँ,
join,
sir.
we'll request him to speak.
Okay.
तो बीच
So
में करा
Bhavya,
लेंगे. I
please.
think Ananya has just joined me. I'll request her to actually, just share the presentation. बेटा 5 वाली करना पहले आप presentation. I just want to recapitulate. मुझे पता है क्या किया है. 12 में आपने आगे से लिया है ना असल में. थोड़ा सा एक बार जरा मैं इंट्रोडक्शन करना चाहता हूँ.
So it's our privilege to have CA Vinod Jain ji as today's speaker. So Vinod Jain ji has a experience of 38 years in the field of taxation, audit, accounting, finance, banking, law education, strategic planning, and business management. Also, he was chairman of NIRC ICI in 1983 to 1984. Also, he was Central Council member of the Institute of Chartered Accountants of India from 1998 to 2004 and again in 2007 to 2013. Also, he served as the chairman of Board of Studies of the Institute of Chartered Accountants of India from 2010 to 2011, being in charge and overall responsibility for the chartered accountants education of about 1 million CA students in the country. He served as chairman of Financial Market and Investor Protection Committee for 5 years. Also, he is a member of high-powered committee appointed by Finance Ministry to simplify income tax laws. He has been appointed as a government nominee director on the board of directors of Coal India Limited. I welcome you, sir, and request to start your technical deliberations. Also, I welcome his team, Advocate Akhilesh ji, Advocate Ananya ma'am, and Advocate Chavi Jain ji, and CA Astha Jain ji. I welcome all his team.
बेटा जरा होस्ट करो आगे. I think Shashi ji has come. Maybe if he can continue. Shashi ji, you can continue, please.
अयो मैं यही बता रहा था कि ये बड़ा आप कंटिन्यू करिए इसको क्योंकि कुछ नेटवर्क इशू आ रहे हैं. तो इंटरेस्टिंग
आपका
टॉपिक है.
network
हम टाइम
issue आ
वेस्ट
रहा है.
इसमें नहीं करें. हाँ कुछ आ रही है प्रॉब्लम.
So, first of all, thank you, CA Dr. Raj Chawla, who has joined us today, and thanks for the nice words, Dr. Raj Chawla, about us and our team. And I also thank Mr. Sunil Garg and Chartered Accountant Malviya. And I especially welcome Shri Shashi Chadda ji. He's a very old friend, each other for about 30 years plus. And of course, whenever we have been going to Panjab, we've been having facilities always. And we, of course, look for his great knowledge which he has gathered dealing with the industry of Haryana, because he was president of the Haryana Chapter of Commerce. So I've seen him, the contribution he has done for the growth of industry in Haryana. So thank you to CS and Dr. Raj to bring Shashi Chadda so that we also get his experience. With me in my team today, Advocate Ananya Madhusudan, Advocate Akhilesh, Advocate Chavi Jain, and Jain. They are coming and going because of the connectivity issues. But this is okay. I think we will go ahead. Before I request Ananya to hosting the web power presentation, I only want to start with this. Succession planning is all about love, money, and control. मैंने शुरू की पिछली बार भी बताया था, ये सिर्फ प्यार का मामला है. मतलब लव तो करें, पैसा भी कमाएं, लेकिन कंट्रोल से रेगुलेट करके सक्सेशन करें उसका. तो लव कंट्रोल पूर्ण बैलेंस आपने है कि पैसे को खाली लव के आधार पर अगर आप करेंगे तो भी गलत हो जाएगा, कंट्रोल नहीं रखेंगे तो बिल्कुल गलत हो जाएगा. कुछ लोग, some people, they transfer their assets during their lifetime to their successors out of their love, and later on sometimes we have seen even very, very large people. You have seen top industrialists of this country, also a few of them. One Mr. Singhania, for example, his own son also requested the father of the house which the father built and passed on to the son. So I think we have to really see that love is there, money is there, but we need to have a reasonable, adequate control and of course succeed in a manner become beneficial for the. Second thing, of course, I think Ananya, you can please host that 5th March presentation a little bit. Just very quickly go through and recapitulate so that people are with us. In a matter of about 5-7 minutes, we'll really update you what we have. बड़ा कर दीजिए. So next slide. Slide next आने में दिक्कत कर रहा है. नहीं बैठ Yeah, okay. You see that, primarily what we have is that succession planning is avoiding family dispute. There are personal perspective, there are business perspective. Personal perspective, of course, is to look after yourself to start with. Look after spouse, your children, your own parents, and of course, ensure that the assets get succeeded in the right manner to right people to whom you really want. Next we go quickly. छोड़ दीजिए आगे चलिए. ये भी चलिए, please go next. Go, please. Go. Yeah. Can you move faster? No. Yes, go. Yes, 1 minute. You see, then of course, what we have told you is, there are two different kind of rules of the game between the Hindu male and Hindu female, because we have also told you one thing that somebody who is not a Parsi, who is not a Christian, who is not a Muslim, is considered as Hindu as far as Hindu Succession Act is concerned. So that means all the inheritance law for other than Muslims, other than Parsis, other than Christians, all that will apply. The Hindu law will apply to everybody else. I think Jews are also excluded. So these only categories which are excluded. All other people, whether you are a Sanatani or you are a Arya Samaji or you are a Vaishnav, or you are not following any other religion, or maybe you are following any other religion of any kind, then you will be subjected to law of succession as far as Hindu is concerned. And Hindu male, primarily there's a first here, legal here, among which everything is distributed in equal. We go to the next slide. I think those between son, daughter, widow, mother, son's wife, daughter's wife. I think this is how, this we have shown you also the property shared between a Hindu male. You've seen in this example, this chart is before us. I'm doing it because we already covered this line. It is only glimpses, and if anybody has, we'll still answer you questions even on these slides. So, in this slide, if you see, we have 6 successors of this male Hindu, one daughter, then a predeceased son, then a mother, the widow, and the deceased daughter. So this is the level 1 here, and because there is a predeceased son, we have predeceased son, daughter, his widow, predeceased son, and again a son. So जो पोता है उनका पोते का भी पोता is also not there in this particular example we have seen. So even his family also will get ultimately inherited. Similar shown about predeceased daughter also. So accordingly, I think this will give you a glimpse and idea how, in case one don't leave specifying an asset, how the assets will go in case of a male. I hope this part has to be very, very clear to everybody. In this case, the part of the property going to on the death of the male Hindu is very important. See, because if this male Hindu has other brothers and sisters, then whether he will really like after his death, whether mother would actually succeed his own way to the further mother has, or mother after death, then there could be complications which are unwanted complications which may happen. That is what also I explained to you. So it is very, very important to plan your succession in a proper and planned manner. We go to the next slide, please. So Hindu female, of course, as far as Hindu female is concerned, we have seen that it goes in the series. The first right, second right, third right, fourth right, and fifth right. It is primarily you see on her death, her husband, her daughter, predeceased son and daughter. I think same thing is there, which is male. But I think the second right goes to heirs of the husband. The third right goes to mother and father. Fourth right goes to heirs of father and fifth right goes to heirs of mother. इसमें एक बहुत महत्वपूर्ण बात मैंने आपको बताई थी कि what female actually inherit from her that normally cannot go to her in-laws in case of further inheritance. Similarly, whatever she inherit from her husband, from her husband's family, not travel by inheritance to her family, father's family or her mother's family. All those precautions have been taken in the Hindu law appropriately, even if you don't plan the succession. Gave you that agnates, there are cognates, there are half blood, there are union blood, and all kind of things we have explained to you. I'm not going into those details now today. We'll go to the next slide. देखिए आगे चलिए. अब और इसकी जरूरत नहीं मेरे ख्याल से, और चलिए आगे. Now you see we are on HUF property. The crucial issue which we were dealing last time was in relation to pre 2005, pre 2006. इसके बाद है पहले थोड़ा सा पहले bit before. Yeah, you see, as just to recapitulate, I recapitulated that before 1956, because this part of the law is not clear to most of us as chartered accountants, and most of the people actually consult the chartered accountants. होगा ancestral property है, shared property कौन सी है, HUF property कौन सी है, क्या HUF अपने आप बन जाती है, HUF को बनाना पड़ता है. There are several questions which people ask single chartered accountant. सारे सवालों का जवाब जो है वो ultimately succession law में छिपा है. देखिए pre 1956 the position before the Hindu succession in 1956 came in. The position was in a HUF. You become a member by your birth, and on your death you cease to be a member of the HUF. So as soon as you become member of the HUF, and in case of females, once the female get married, they used to cease to be member of the HUF. And similarly, any women which is coming to the HUF after marriage, she also becomes part of the HUF. The wife of the co-partner becomes part of the family. But the females at that time had no co-partner right. The co-partner right were only with males. Neither with daughters nor with wives. There was no co-partner right which was available. And it is only male members that they could have asked for division. The division right asking was only with co-partners. Although once co-partners, on the basis of co-partners, the division takes place, then the division may result into going certain properties used to the females also, because they were also members. Because, for example, there is an unmarried daughter and the division is happening in leaps and bounds, 100% division is happening. That share we go to the next. Now, after 1956, the position undergo a change. Section 6 of the 1956 Act, of course, it says that whenever a male Hindu having an interest in Mitakshara co-personal property, the commencement of this Act, then his interest in the property will devolve by rule of survivorship and not in accordance with the Act. However, if the Mitakshara co-personal died leaving behind a female heir of class 1 or male heir claiming through her, then the interest would devolve by testamentary or intestate taxation in accordance with this Act, and survival will be inapplicable. उन्होंने दो हिस्सों में बांट दिया कि whether you leave a female here or leave a female here. तो अब तो ये देखिए 2005 तक था. 2005 के बाद का the daughter did not have any right to seek partition. Daughters were neither co-partner nor they have any right to seek partition. That was that situation even till 5. Now and we are aware that daughters were given right in the assets of the father much earlier. When we are self-acquired property, that is why it becomes important what is self-acquired property, what is ancestral property, and I think now with the help of case law, and understand what to this what is self-acquired property, what is inherited property, and what is HUF property. We go to the next. So I think 2005, I think in 2005 a major change came in. And this is the current law in which we are living. And I think when we'll be dealing with case laws after case laws of Honorable Supreme Court, I think things will become unfold to us, slowly will become clear, because initially we'll be talking about the case laws which relates to the earlier law. Then we'll start talking about the latest case laws which is coming. And after the 2005 law got implemented. So देखिए, according to section 6 in the HUF governed by Mitaksara law, जो नया कानून है उसने बताया, a daughter shall become a co-partner in her own right in the same manner as son. तो देखिए, पहली बार 2005 में with effect from 20th day of December 2004, all daughters got a right on their own of a co-partner. जो बेटों के पास right as is rights with the daughters. So she would have the same right in the co-partnership property as that of a son. She shall be subjected to same liabilities in respect of said co-property as that of a son. Any disposition or alienation, एक बड़ा important उन्होंने दिया कि जिसे कहते जाते उन्होंने कहा भी ये पीछे के केसेस का क्या होगा. उन्होंने कहा any disposition or alienation, including any partition or testamentary disposition, मतलब किसी ने डिस्पोज कर दिया प्रॉपर्टी एचयूएफ ने, या कुछ एलिनेशन हो, या कोई पार्टीशन हो गया हो, या कोई आपने टेस्टामेंट्री मतलब कोई डॉक्यूमेंट बना के कोई डिस्पोज कर दिया, प्रॉपर्टी को बांट दिया लोगों में, अगर वो 20 दिसंबर 2004 से पहले हो गया तो नया कानून नहीं लागू होगा. तो पुराने कानून चलेगा, पुराने जो डिस्पोजिशन हो चुके हैं उनको रीओपन नहीं किया जाएगा. क्योंकि नॉर्मली इफ द डेथ हैज हैपेंड बिफोर 20th day of December 2004, because death होता है succession, if the death has happened before 20th day of 2004, in that case the earlier law will prevail, and on that already disposition or alienation would have happened based on the previous law. But in case the death happening after 20th day of December 2004, then this law will apply retrospectively. The daughters had always had that right. आप ये नहीं कह सकते कि 2004 के बाद जो लड़कियां पैदा होने मिलेगा, जो भी डॉटर्स हैं उनको ये राइट एक तरीके से रेट्रोस्पेक्टिव हो जाएगा, वो जब से बॉर्न हुई, जब एज सून एज दे बिकेम मेंबर ऑफ द फैमिली, जब से. इसमें एक और बहुत महत्वपूर्ण बात यह है कि लड़कियों की शादी हो जाएगी तो भी वो आपकी एचयूएफ का हिस्सा रहेंगी. कई बार लोग सवाल उठाते हैं, भाई ये हमारी एचयूएफ का हिस्सा की लड़कियां, इनके शादी हो गए, उन्होंने शादियों में पैसे खर्च दिए और बहुत सारा काम हो गया. तो इस बात मैं जरूर पूरे समाज के सामने रखना चाहता हूँ, चार्टर्ड अकाउंट समाज, क्योंकि थिंकिंग प्रोसेस को बहुत अच्छे से डिटरमिन करता है. देखिए, अल्टीमेटली व्हेन वी आर टॉकिंग ऑफ फीमेल्स, अब हमारे साथ अन्य भी हैं, छवि भी हैं और अखिलेश जी, ऋषि जी हैं. हम लोग सब इस बात करते हैं कि when a lady come after marriage to a family, you see the entire succession law does not give her any right on the properties of the husband. It is only on the death of the husband that she had some proportionate right with the mother and the children. Before the husband, she has no right on the husband's property. उसको जहां वो शादी होकर गए वहां पर उसका कोई कानूनी हक नहीं है. इस बात को समझना देखिए बहुत जरूरी है लड़की का. तो जो लड़की शादी होकर आएगी उसका जो फैमिली की प्रॉपर्टी पे, फादर की, हस्बैंड की प्रॉपर्टी पे, हस्बैंड के फादर की प्रॉपर्टी, किसी तरह का कोई हक नहीं है. नो ओनरशिप ऑफ एनी काइंड. Whereas if we see the western world, ये यहाँ पे बड़ी इंपॉर्टेंट बात आपके सामने रखने वाला हूँ. When we see the western world of US and Canada, more importantly, I've seen the Canadian succession law very carefully. In the Canadian succession law, for example, as soon as Mr. A male member, Mrs. A, जैसे ही उनकी शादी होती है तो शादी होने के बाद वो कभी भी अगर हैं तो उनकी दोनों की प्रॉपर्टीज को जोड़ के 10 करोड़ की प्रॉपर्टी हस्बैंड के पास है और 20 करोड़ की प्रॉपर्टी वाइफ के पास है, या समझो 5 करोड़ की प्रॉपर्टी है तो 5 और 10 15 करोड़ की प्रॉपर्टी हो. और अगर कल को उनका पार्टीशन होता है, उनका डिवीजन होता है, उनका डाइवोर्स होता है, तो 7.5 करोड़ टू ईच वन विल गो. As soon as a lady marries a male, she becomes entitled to 50% of his property. Similarly, the male also become entitled to 50% property of the female. इसीलिए हम देखते हैं वेस्टर्न वर्ल्ड में 60 साल की उम्र में, 80 साल की उम्र में बहुत शादियां होती है. Because females get married to and similarly males also. Males get married to well-to-do ladies, and females get married to boys or you can say old people. So ये वेस्टर्न वर्ल्ड में बहुत कॉमन है. खैर हम वेस्टर्न वर्ल्ड की प्रथा अपने यहाँ नहीं लाना चाह रहे हैं, बट अल्टीमेटली व्हाट आई एम ट्राइंग टू से इज कि भी जस्टिफाइड है जो भी हिंदू सक्सेशन लॉ ने किया कि एटलीस्ट डॉटर्स हैव सम राइट ऑन द एसेट्स ऑफ देयर ओन फादर. To that extent it is justified. We go to slide please. अब देखिए एक और भी बड़ा इंपॉर्टेंट उन्होंने बताया कि नॉट ओनली मेल्स बट ऑल्सो फीमेल्स बिकम एंटाइटल्ड बाय वर्च्यू ऑफ सबसेक्शन 1. जो भी उनको प्रॉपर्टी मिलेगी दे कैन डिस्पोज इट ऑफ बाय टेस्टामेंटरी डिस्पोजिशन. ये बड़ी पिक्यूलर बात है. जो भी उनका हिस्सा, whatever is her share or his share, so before the death you can always have a testamentary disposition of your own share. आप अपने बच्चों का शेयर एचयूएफ प्रॉपर्टी में डिस्पोज ऑफ नहीं कर सकते. अपना खुद का शेयर, मैंने भी आपको शेयर बताया था ना. बाकी अभी एक मैं चार्ट आपको दिखाने वाला हूं, एचयूएफ का चार्ट. एचयूएफ के चार्ट के माध्यम से आपको पूरी बात क्लियर हो जाएगी. इसके बाद है ना एचयूएफ का चार्ट या पहले है? नहीं डाला, चार्ट नहीं डाला. अच्छा, एचयूएफ का चार्ट शायद इन्होंने डाला नहीं. विल शेयर दैट चार्ट लेटर. सो Section 3, Hindu dies after commencement of Hindu Act, his interest in the property of joint Hindu family governed by law shall devolve by testamentary or intestation as the case may be. तो देखिए इन्होंने दोनों ऑप्शन दिए हैं. In case you die intestate, then your asset will go by intestate taxation, means जो हिंदू सक्सेशन लॉ भी हमने आपको बताया उसके हिसाब से आपके प्रॉपर्टी में जो आपका हिसाब से बढ़ जाएगा. एक बड़ी महत्वपूर्ण बात 2005 के कानून ने कही कि इन केस ऑफ डेथ एचयूएफ प्रॉपर्टी एज्यूम करते हैं देयर इज एज इफ देयर इज ए टेक्निकली देयर इज ए पार्टीशन ऑन द डेट ऑफ द डेथ. भी किसी एचयूएफ की डेथ होगी, हम देखेंगे भाई उसका कितना हिस्सा था इमीडिएटली बिफोर द मैरिज, इमीडिएटली बिफोर द डेथ. उसका अपना कितना हिस्सा था, उसके अपने हिस्से में से जो उसके सक्सेसर्स हैं, सन, डॉटर, वाइफ, उनका हिस्सा हम निकाल देंगे क्योंकि उन हिस्सों को पे उसका इन एचयूएफ प्रॉपर्टी इस इंसान का कोई हक नहीं है. लेकिन एचयूएफ प्रॉपर्टी में आपका हक सिर्फ आपके अपने हिस्से पर है. तो आपका लिया 1/5 है, आपके पास एक डॉटर है, 2 सन है, वाइफ है, तो आपका हिस्सा 1/5 है इन दिस एचयूएफ. प्रैक्टिकली 5 मेंबर है एचयूएफ के, तो आपका जो 1/5 हिस्सा, अगर मान लिया आपकी 100 करोड़ की प्रॉपर्टी है एचयूएफ में, तो आपका जो 20 करोड़ है, लोग सोचते हैं एचयूएफ में मैं जिसे मर्जी दे जाऊं, ऐसा कुछ हक नहीं है आपके पास. आपके पास हक है सिर्फ आपके 1/5. तो जो आपका 1/5 शेयर है वो आप चाहे इंटरस्टेट में छोड़ जाए तो इंटरस्टेट में चला जाएगा, और आप चाहे किसी थर्ड पार्टी को दे दें. आप अपने परिवार में अपना शेयर नहीं देना चाहते, आपको परिवार के लोग से लुक आफ्टर नहीं करते, आप उन्हें लाइक नहीं करते, उन्हें लव नहीं करते, कोई नहीं है, तो आपने कहा मैं अपना इसको नहीं देके जाऊंगा. तो आपने यू कैन ऑफ कोर्स एग्जीक्यूटिव एंड बाय वर्च्यू दैट शेयर कैन बी गिवन टू इवन अ थर्ड पार्टी. आई होप आई एम क्लियर अबाउट इट. सुनील जी, ये एक इशू है, ये इससे समझना बहुत जरूरी है. आपके जो व्यूअर्स हैं उनमें किसी के कोई क्वेश्चंस हैं, क्वेश्चंस को हमें देख लेना जरूरी है. आई वेलकम छवि जी टू द मीटिंग. छवि, वेलकम टू यू. सो वी गो टू द नेक्स्ट स्लाइड प्लीज. तो देखिए मैंने बताया कि जब डेथ होगी तो एक नोशनल पार्टीशन होगा. एक्चुअल पार्टीशन इज पार्टीशन ऑफ एसेट. द डॉटर इज अलॉटेड द सेम शेयर एज ऑफ द सन. द शेयर ऑफ predeceased daughter allotted to the child of such predeceased son or such predeceased daughter. शेयर ऑफ predeceased child of predeceased son. तो एक फैसला कैसे कितना शेयर है, फैसला होगा ऑन द बेसिस ऑफ ए नोशनल पार्टीशन. अगर मान लिया लीव्स एंड बाउंड्स में 100% पार्टीशन उस दिन किया है, एक्शन नहीं अप्रिशिएट दिस, तो हम देखेंगे जो जिस आदमी की डेथ हुई है, जिस लेडी की डेथ हुई है, उसका कितना हिस्सा था, उसका अपना हिस्सा. Interest of Hindu in co-partition shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his or her death. So after the commencement of the Amendment Act, there shall be no obligation on the son, grandson or great-grandson for the recovery of any debt due from his father. ये भी देखिए बड़ा एक important change आया है कि फादर की, ग्रैंडफादर की और ग्रेट ग्रैंडफादर की प्रॉपर्टीज का क्या के ऊपर ऑब्लिगेशन होता था, मॉरल ऑब्लिगेशन होता था, पायस ऑब्लिगेशन होता था हिंदू लॉ. क्योंकि फादर जो आप समझो अपने ऑब्लिगेशन छोड़ गए हैं, डेट छोड़ गए हैं, ग्रैंडफादर कुछ, ग्रेट ग्रैंडफादर को छोड़ गए, तो आपका एक पायस ऑब्लिगेशन था कि आप उनके सारे उधार चुकाएंगे. वो पायस ऑब्लिगेशन ने स्पेसिफिकली खत्म कर, सिर्फ ऑब्लिगेशन इतना बचा कि सपोज यू इनहेरिट एनीथिंग फ्रॉम मिस्टर ए, then to the extent of inheritance from Mr. A, if Mr. A has some liabilities which are attached to him, in that case those liabilities of course you will have to pay. Otherwise ये नहीं कि आपने अपने हिस्से में उसको, वो पायस ऑब्लिगेशन खत्म हो गया. प्लीज अप्रिशिएट दिस. और बाकी अचीव का भी कोई ऑब्लिगेशन नहीं है जो उनकी अपॉर्चुनिटीज है. प्लीज अप्रिशिएट. So nothing contained in amended section shall apply to a partition which has been effected, I am again repeating, before 20th day of December 2024. तो अब मेरे ख्याल से केस लॉज है. अनन्या, will you take up the case laws one by one? We go to the case laws. मेरे ख्याल से आप, ये तो पुराना है, इसको हमने कर लिया था, इससे आगे चले मेरे ख्याल से. आपने चले नहीं. मैंने अपना मुंह म्यूट कर लिया. So that you can take up. Please hold on. I think I'm coming back to you again.
So, good afternoon, everyone. So, as we've already discussed right now, the brief of what we had conducted in the previous session. So, now we'll be discussing various case laws with respect to Hindu undivided family, ancestral property, self-acquired property, joint family property, and co-pastoral property, as to what is the difference between each one of them. To begin with, what is HUF? What is considered as an HUF property? So, HUF property is not defined anywhere in the legislation. However, through various case laws, a brief idea has come out about what constitutes as an HUF property. The moment, so in the what the Supreme Court has stated is that the moment a son is born, he gets a share in father's property and he becomes part of the co-pastoral. It's necessary to note that with the amendment, this is
I think please wait. I think let her screen come. I think she is yet to host her screen.
Is it visible now, sir?
No. आनी शुरू हुई है. सब आ गई. अभी से बड़ा कर दो. Full screen कर दो. Now you can do it.
So, as I was stating earlier, in the case of Yudhishthira versus Ashok Kumar, the Supreme Court has held that the moment a son is born, he gets a share in the father's property and becomes part of the co-pastoral. Please note that this is applicable for a daughter also in light of the 2005 amendment. Thereafter, the court held that his right accrues to him not from the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, whenever the father gets a property from whatever source, from the grandfather or from any other source, be it separated property or not, his son should have a share in that, and it will become part of the Hindu family of his son and grandson and other members who form a joint Hindu family with him. The court observed that this position has been affected by Section 8 of the Hindu Succession Act, and therefore, after the act, when the son, and this part is very important to note, when the son inherits the property in the situation contemplated by Section 8, He does not take it as karta of his own undivided family, but takes it in his individual capacity. In that view of the matter, it would be difficult to hold that the property which developed on a Hindu under Section 8 of the Act would be a HUF in his hand vis-a-vis his own sons. If that would be the position, then the property which developed upon the father of the respondent in the instant case on the demise of his grandfather could not be said to be HUF property. If that's so, then the appellate authority was right in holding the respondent was a licensee of his father in respect of the ancestral house.
You see, as she has actually introduced to us, this is a law which is an old law because you see the date of the judgment. This is a 1986 judgment. And this law is currently not applicable. But why we are introducing this law is so that we can actually understand how the law has developed. We go to the next. I only wanted to add this much. Go to the next. Yeah.
The next, I would like to bring to your attention the case of Sani versus Raj Singh, wherein the court has held that after passing of the Hindu Succession Act, and this is a 2015 judgment, so this is post-amendment, the possession has undergone a change, and if a person after 1956 inherits a property from his paternal ancestor, the said property is not an HUF property in his hands, and the property is taken to be as a self-acquired property of the person who inherits the same. Now, there are two exceptions to the property which is inherited by such a person, being and remaining self-acquired in his hands, and which will be either an HUF, and his property was existing even prior to the Hindu Succession Act, and which Hindu undivided family continued even after passing of the Hindu Succession Act. And in which case, since HUF existed and continued before and after 1956, the property inherited by a member of an HUF even after 1956 would be a HUF property in his hands, to which his paternal successors' interest up to 3 degrees would have a right. This is where it's pertinent to note that an HUF property would basically mean that any property to which the paternal ancestors had a right, up to 3 degrees would have a right. So, for instance, my father, his father, my father's father, and my father's father's father, that property which I inherit would constitute as an ancestral property which would form part of my HUF. The second exception to the property in the hands of a person being not self-acquired property but an HUF property is if after 1956 a person who owns a self-acquired property throws the self-acquired property into a common hodgepodge, whereby such property or properties become joint Hindu family property or HUF properties. So the first option is that either the property has to be has to be inherited by 3 generations from the paternal aspect, or that a self-acquired property is with the proper intention is thrown into a common hodgepodge of the HUF property. And in these 2 cases, it will constitute as an HUF property. In order to claim the properties in the second exception, which is the common hodgepodge, as I've explained, as being HUF property, a plaintiff has to establish to the satisfaction of the court that when was a particular property or properties thrown into common hodgepodge, and hence HUF was created. Now, what constitutes as a self-acquired property and an ancestral property with respect to an HUF? It's very pertinent to know that these terms are not defined anywhere in the Act. However, they've been developed through the multiple plethora of judgments by various forums. So, in the case of Surendra Kumar versus Shri Dhaniram, the Delhi High Court has held that if a person dies after passing of the Hindu Succession Act, and there is no HUF existing at the time of the death of such a person, inheritance of an immovable property of such persons by his successors is no doubt inheritance of ancestral property, but the inheritance is as self-acquired property in the hands of the successor. So, for instance, that if an individual has died after the commencement of the Act, and at the time of the death of the individual, there was no HUF existing, then as a successor to that individual, for me, that would be a self-acquired property. However, it would constitute as an ancestral property. Although the successor indeed inherits ancestral property, that is a property belonging to his parental ancestor. So while it's an ancestral property, for me, as the person who's inheriting the property, it would constitute as a self-acquired property. The only way in which HUF or a joint Hindu family can come into existence after 1956, and that is when a Hindu joint family did not exist prior to 1956, is if an individual's property is thrown into common hodgepodge. Thus, if an HUF property exists because of its such creation by throwing of self-acquired property by a person in the common hodgepodge, consequently, there is entitlement in co-partners to a share in such HUF property. So prior to 1956 Act, as Sir explained, every property was considered as a property of the HUF. However, after the introduction of the Hindu Succession Act, in order to create an HUF, there has to be certain property which has self-acquired property which has to be thrown in the common hodgepodge in order to give it the title of a HUF property. An HUF can also exist if maternal ancestral properties are inherited prior to 1956, and such status of parties qua the property has continued after 1956 with respect to properties inherited prior to 1956 from paternal ancestors. Once the status and position continues even after the 1956, after the introduction of the Act of HUF and of its property existing, a co-partner will have a right to seek partition of the said properties. Even before the introduction of the Hindu Succession Act, an HUF can come into existence even without inheritance of ancestral property from paternal ancestor, and HUF could have been created prior to 1956 by throwing of individual property into common hodgepodge. If such HUF continues even after 1956, then as I stated earlier, a co-partner will have a right to seek partition of such property. Now, we've been using a lot of terms that self-acquired property and co-partnership property. However, what is known as co-partnership property? So this has, again, like I've stated earlier, these terms are not anywhere defined in the Act. So through plethora of judgments, it has been defined. A co-partnership, in the Supreme Court has held that a co-partnership is a narrower body than a joint family and consists of only those individuals who have taken by birth an interest in the property of the holder for the time being and who can enforce a partition whenever they like. It commences with a common ancestor and includes a holder of joint property and only those males in his male line who are not removed from him by more than 3 degrees. The word survivor usually applies to the longest lives of 2 or more partners or trustee and has been applied in some cases to the longest liver or joint tenants and legatees and to others having a joint interest in any property. Now, this is it has further been explained in a very recent judgment of the Supreme Court that a co-partner property means the property which consists of an ancestral property, and a co-partner would mean a person who shares equally with others in inheritance in the estate of the common ancestor. Like I stated earlier, co-partnership is a narrower body than a joint Hindu family, and before the commencement of the 2005 Act, only male members of the family used to acquire right in it by birth. An interest in the co-partner property. A co-partner has no definite share in the co-partner property, but he has an undivided interest in it. And one has to bear in mind that it enlarges by the entire focus of the family. Now, we've discussed what a co-partner property is. Now, what do we mean by a joint family property? Because in the plethora of judgments, we see that terms co-partner property, joint family property, HF property is being used. So, it has been held by the courts that the general doctrine of Hindu law is that property acquired by a karta. Karta is the head of the Hindu undivided family, or a co-partner with the aid or assistance of joint family assets is impressed with the character of a joint family property. To put it differently, it is an essential feature of a self-acquired property that it should have been acquired without assistance or aid of the joint family property. In essence, what this judgment is saying that for a self-acquired, in the case of self-acquired property, it has to be acquired by funds of an by individual's own funds. However, in case of a joint family property, it has to be acquired with the funds of the joint family. The test of self-acquisition by the karta or co-partner is that it should be without detriment to the ancestral estate. It is therefore clear that before an acquisition can be claimed to be a separate property, it must be shown that it was made without any aid or assistance from the ancestral or joint family property.
I will explain this a little bit, because this part is very crucial for all of us to understand, because these decide all kind of litigation happens primarily around these points. Suppose you are starting in a new venture, buying an asset. So what is the source of money for that? Becomes very crucial to actually decide whether it is going to be a family property or it is going to be a self-acquired property. तो अगर आप बिजनेस मान लिया ancestral property से अच्छे property से पैसा draw करके किया है, In that case, there will be broadly an assumption that it is since this is based on family property. उसका जो fulcrum है, fulcrum actually is the family property or family money. In that, whatever is grown, you invested suppose 10 lakhs from family property, and then based on this, today the business has been crores. So 900 crore business will not be your self-acquired business. It will primarily, it might be even invested in your own name. It is possible. तो the proprietor क्या business है? बंद करता हूँ एक मिनट, just a minute. मैं आप बंद करो, मैं okay. So really it's gone. I'll continue in the mail before she brings the slide on the screen. What I was trying to say was that it is very important for us to differentiate between the family property and the self-acquired property. So whatever businesses are built, whatever assets are created, whatever wealth is created, it should be created on property, or the fulcrum should be self-acquired property if you do not want any dispute with your other brothers or your sisters or maybe Chacha ji or Taya ji, and this is all a family business. A dispute can get created and can take a very long time. In a very large number of cases, you will find this dispute coming from your own sons and daughters, your sons and your granddaughters. Because when the assets become larger and larger, the disputes become deeper and deeper. So that's why it is very important. How do you really plan yourself? आपने पैसा दिया, कई बार आपको लगता है नहीं सर पैसा तो मेरे को फैमिली से लेना पड़ेगा व्यापार शुरू करने के लिए. From where will I bring the money? I am just born. मेरे पास अपना पैसा नहीं. I think that is actually advise our client. शशि जी बड़ी इंपॉर्टेंट बात है समझने के लिए, और हम सब बिजनेसमैन साथियों को समझानी है कि अल्टीमेटली इवन इफ सपोज यू वांट टू एक्चुअली टेक मनी फ्रॉम फैमिली एंड स्टार्ट अ बिजनेस, रास्ते और हैं. एक रास्ता तो ये है कि जो करता है हमारी फैमिली का, अगर करता वो पैसा एक आपको चिट्ठी देता है, भाई ये देखो ये पैसा है, ये 10 लाख रुपए आपको निकाल के दे दिया फैमिली का हिस्सा से, दिस आई एम गिविंग यू इंडिपेंडेंटली, इट इज बीइंग गिवन टू यू. दैट राइट एवरी करता है. तो मेरे पास 10 करोड़ की प्रॉपर्टी है, मैंने बेटे को कहा या पोते को कहा ये 10 लाख रुपए देता हूँ या 50 लाख रुपए देता हूँ, ये आज से आपके हुए, फैमिली के नहीं है. एंड आई ऑल्सो क्रिएट पेपर very clearly while elect, then in that case that is no more a family property. Actually वो एक तरीके से फैमिली ने अपना पैसा डिस्पोज ऑफ कर दिया. जैसे शादियों में पैसा खर्च देते हैं, ऐसे किसी को व्यापार के लिए उन्होंने दे दिया, और बड़ा एक्सप्रेसली कहना जरूरी है कि दैट इट इज नॉट नॉर्मली आपका लेना देना कुछ नहीं, आप अपना व्यापार अलग करो, ये आपको पैसा दे दिया. हम उसमें ये कहना जरूरी नहीं है कि आपका हिस्सा आगे कुछ नहीं रहा, उसे बेदखल करना जरूरी नहीं है. इससे दूसरा और भी आसान हो सकता है कि हम उनको उधार, वी कैन ऑलवेज गिव ए लोन. 10 lakh interest free loan can be given, 10 lakhs, 20 lakhs, 100 lakhs, 2 crore, 5 crores interest free loan can be given. If you do not want tomorrow any झमेला भी आपने अपने बेटे को पैसे दिए और करता, and tomorrow चाचा जी, ताया जी and everybody comes in between, please appreciate it, because it is a big issue. Like for example, client, this issue which we are bothering is, the grandfather, rather, I think the great grandfather started this business. This is a business based in Delhi. It consists of a large number of 5-star properties, 5-star hotels properties, as well as it consists of cinema halls and other things. So, किसी बहुत सीनियर आदमी ने शुरू किया था. अब कौन सा पैसा कहां से आया उसकी ट्रेस ही नहीं रखी गई. हालांकि पैसा सब कंपनीज में लगा है, इंडिविजुअल नामों में लगा हुआ है, पर जो आज की जो जनरेशन है, जो 40 साल 45 साल के आसपास की है, जिनके बच्चे कल को बिजनेस में आने वाले हैं, they are telling their father, please divide this property, this all is your property, this is not your property. Father is saying, oh, nothing doing, all these 5-star hotels I only created. There was no 5-star hotel when I came into business. This is all my money. Get lost, and litigation is going on. Please appreciate this. So litigation between son, and when there are more than one son, then that litigation becomes more deeper. And when there is son who has extra expenses, or who is more money, or who's going into bad company may become a bigger problem creator. So they all it is very important for us to plan that who owns what. So self acquired property है तो आपका पूरा हक है जिसे मर्जी दे, लेकिन अगर एचयूएफ प्रॉपर्टी है तो डिवीजन मांगने का को-पार्टनर्स को पूरा है. ये वाली बात प्राइमरली देखिए 1960 56 से पहले भी यही थी, 56 के बाद भी यही है. प्रॉपर्टी होगी तो फैमिली रहेगी. मेजर चेंज जो आया, जो हमें अनिल जी समझाना चाहते हैं, वो आया 2005 के बाद कि आप शेयर एचयूएफ में है, on date of death you can actually bid to your successors to a third party by testamentary dispose. मतलब आप अपनी विल से किसी को भी दे सकते हैं. तो आप डॉटर का हिस्सा है 1/5 का, वो चाहे तो अपनी विल किसी हिस्सा फैमिली की प्रॉपर्टी का, तो आप उसका कुछ नहीं कह सकते उसे भी तूने किसी और को कैसे दे दिया. That will happen only in case of if she wants that share, she has to ask for a division now. उसको डिवीजन मांगना पड़ेगा फैमिली प्रॉपर्टी का. बट जो आपकी सेल्फ एक्वायर्ड प्रॉपर्टी, आपने सैलरी से पैसा कमाया, आपने अपने पैसे से या दोस्तों से उधार लेकर, बैंक से उधार लेकर बिजनेस शुरू किया, दैट इज ऑल योर सेल्फ एक्वायर्ड प्रॉपर्टी. उसके ऊपर किसी भी लीडर का, ना आपके सन का, ना डॉटर का, ना ग्रैंडसन का, ना ग्रैंड डॉटर का, किसी का कोई भी हक नहीं है. प्लीज अप्रिशिएट दिस. और अगर आपने सक्सेशन किया द्वारा, तो आपने बिल द्वारा अगर अपने बेटे को दिया, तो भी आपका ग्रैंडसन फिर आपके बेटे को तंग नहीं कर सकता. नहीं जी ये तो मेरा हिस्सा है, ये तो दादाजी से आपके पास आया है. बिकॉज वेन एवर इट गोज बाय टेस्टामेंटरी सक्सेशन, in that case it goes as a acquired property. It does not come as an inherited on which the further successors will have right. देखिए बड़ा बारीक सा फर्क है, इसे जरूरी है. तो हम सवाल जरूर लेंगे इस इशू पर, बाद में एग्जांपल्स के तौर पर आगे जी, क्योंकि ये पार्ट अगर समझ में आ गया तो समझिए सक्सेशन तो प्रॉपर्टी सक्सेशन के सारे जमेले समझ में आ गए. क्योंकि जरा सा अगर हम अपने क्लाइंट्स पर चले ठीक से, हमारे क्लाइंट्स को दिक्कतों का सामना नहीं करना पड़ेगा. देखिए सबसे ज्यादा चार्टर्ड अकाउंटेंट इसको ढूंढना है, इसको कंट्रीब्यूशन दिखाना है, क्या दिखाना है, पैसे का सोर्स कहाँ आया, कंफर्मेशन जो इनकम टैक्स डिपार्टमेंट में हम फाइल करते हैं उसमें हमने क्या फाइल किया, ये सारी चीजें बड़ी महत्वपूर्ण है. सोर्स का सोर्स जो हम बताते हैं, वो सारी चीजें हमें इन सारी चीजों को ध्यान में रखते हुए ड्राफ्ट करनी है, ताकि हमारे क्लाइंट्स को कल को लिटिगेशन का सामना ना करना पड़े. हमने गलती से गलत कोई आपने फाइल कर दिया कि नहीं सर ये तो हमारी फैमिली से आया था हमारे पास. आपने एक बार डिक्लेरेशन दे दिया भाई सोर्स इज फैमिली मनी, इट इज इनहेरिटेड फ्रॉम माय फादर्स फादर, आपने ये लिख के इनकम टैक्स डिपार्टमेंट में फाइल किया सोर्स ऑफ सोर्स, तो इन दैट केस योर सन और ग्रैंडसन में आर टुमारो फ्रॉम दिस प्रॉपर्टी. प्लीज अप्रिशिएट, बी प्रिपेयर्ड फॉर दैट. अब ये नवतेज सिंह जो 2013 का जजमेंट है, इसके बारे में पंजाब हरियाणा हाईकोर्ट का अनन्या जी बताएंगे आपको. अनन्या जी बताइए.
So, as already sir has explained,
आपकी चली गई, वो स्क्रीन चली गई. स्क्रीन क्या चली जाती है आपकी? Just a minute, let her share. Just a minute, she'll share her screen again.
so as sir has already explained right now, that the entire essence of a self-acquired property is that it has to be a separate property. It has to be acquired by the funds of an individual. However, the essence of a co-partnership property in terms of the Midakshara law is the unity of ownership. The ownership of a co-partnership property is in the whole body of co-partners. According to the true notion of a undivided family governed by Midakshara law, no individual member of that family, while the property remains undivided, can predicate of the joint and undivided property. No individual has the right to sell any joint family property without if no partition has taken place, in a sense. It's also necessary to note that the right to succession is a statutory right. It cannot be taken away except in terms of a later statute, which might have an overriding effect with a non-extant clause, which is a complete which is a complete code itself. Now we've been talking about the survivorship, the right of survivorship, and how the property is devolved by rule of survivorship. However, what does that exactly mean? So, in the case of Uttam versus Sabhag Singh, the Supreme Court has held that on the application of Section 8 of the Hindu Succession Act, either by reason of the death of a Hindu male leaving self-acquired property, or by application of Section 6, such property would devolve only by intestacy and not survivorship. On a conjoint reading of Section 4 of the 4, 8, and 19 of the Act, after joint family property has been distributed in accordance with the provision of Section 8, the joint family ceases to be a joint family property in the hands of the various person who have succeeded to it, as they hold the property as tenant in common and not as joint tenants. Now, we've also seen that by the 2005 amendment, daughters have received multiple rights, as basically rights as that of the son, as well as their response.
Actually, screen पे जाओगे. I want to just explain this.
You see, this Uttam Singh versus Sobhag Singh is a very, very confusing judgment. That is what I wanted to actually really, tell you. ये भी judgment अनन्या जी ने बताया है, लेकिन हमें ठीक से अभी तक not still got into our minds. It has a very, very strong bearing on what is going to happen. And what Supreme Court is doing, I'm not sure. Supreme Court up to, and I think it will become more clear, see later judgments. But let us see what Supreme Court is trying to say. Supreme Court ने कहा that the application of Section 8 of the Act के हिसाब से अगर कोई मृत्यु की डेथ हो जाती है, self acquired property, or by application of Section 6 provision, such property would devolve only by and not by survivorship. इसका मतलब उन्होंने कहा कि आपकी जो सेल्फ एक्वायर्ड प्रॉपर्टी अगर आपने छोड़ी तो वो सर्वाइवरशिप पर नहीं जाए, सिर्फ इंटेस्टेसी मतलब जो हमें बताया, अभी हमने सक्सेशन बताया ना, पहले वाइफ के पास फर्स्ट लाइन, सेकंड लाइन, मेल हिंदू, उसके हिसाब से जाएगी. फिर उन्होंने सेक्शन 8 और 19 ऑफ द एक्ट आफ्टर जॉइंट, अब जॉइंट हिंदू फैमिली प्रॉपर्टी की बात करें, ऊपर उन्होंने बात की सेल्फ एक्वायर्ड प्रॉपर्टी की. सेल्फ एक्वायर्ड प्रॉपर्टी डेथ जाएगी आपके नॉर्मल इनहेरिटेंस के नियम, सक्सेशन के लॉ हैं, इंटेस्टेसी से, या फिर आपने अगर विल छोड़ दी तो विल के हिसाब से. ऑब्वियसली दैट इज द फर्स्ट पैराग्राफ. नाउ वी गो टू द सेकंड पैराग्राफ ऑन सेक्शन 419 when we read them together of the Hindu Succession Act. After joint Hindu family property has been distributed in accordance with Section 8. देखिए सेक्शन 8 क्या कह रहा है, आप प्रिंसिपल ऑफ इंटेस्टेसी के बेसिस पर आप इसे डिवाइड कर दो. तो अगर आपकी जो जॉइंट हिंदू फैमिली प्रॉपर्टी इन्होंने बताया, ये हमने बताया कि आप एक नोशनल पार्टीशन कीजिए, लेकिन ये सुप्रीम कोर्ट जजमेंट बड़ी डिफरेंट मीनिंग दे रहा है हमें. नोशनल पार्टीशन के बाद ये कह रहा है द जॉइंट फैमिली प्रॉपर्टी सीज भी जॉइंट फैमिली प्रॉपर्टी in the hands of various persons who have succeeded to it, as they hold the property in tenant as common, not as joint tenant. का मतलब ये है, जो हमें समझ में आ रहा है कि भाई इसके बाद ये एचयूएफ प्रॉपर्टी नहीं बचे. तो आपका इस प्रॉपर्टी जिस दिन आप मान लिया मिस्टर ए की, who is the grandfather for example, there is a notional partition, and arising out of that notional partition जितने भी इससे एचयूएफ के हुए वो एचयूएफ भंग हो गए. It becomes property of the respective persons. You know, that is how actually I read. These are the exact wordings of the Honorable Supreme Court. Please appreciate this. And the law, every single word of the Honorable Supreme Court becomes law in itself of the country. But ये इस पार्ट को थोड़ा रिफाइन किया आगे आने वाले सुप्रीम कोर्ट जजमेंट्स ने, वो हम उसको मिलके पढ़ रहे हैं, so that all of us actually can interpret it in our own manner. चलिए आगे चलते हैं.
Disposition. That Section 6, as amended, stipulates that on and from the commencement of the 2005 Act, the daughter of a co-partner shall by birth become a co-partner in her own right in the same manner as the son. It is apparent that the status conferred upon sons under the old section, that is, prior to the amendment, and the old Hindu law was to treat them as Kopasnas since birth. The amended provision now statutorily recognizes the rights of Kopasnas of daughters as well since birth. That both the sons and the daughters of Kopasna have been conferred the right of becoming Kopasnas by birth. It is the very factum of birth in a Kopasnary that creates a Kopasnary. Therefore, the sons and daughters of a Kopasna become Kopasnas by virtue of their very birth. That the right to partition has not been abrogated. The right is inherent and can be availed by any Kopasna. And since now a daughter can be a Kopasna, she can also ask for partition in the property. On and from September 9, 2005, the daughter is entitled to a share in the ancestral property and the Kopasna as if she had been a son.
Go to the next.
Now, it's also very important to know that in multiple instances, we see that a child decides to convert and from Hindu to another religion. So, in that case, what are the rules of inheritance? So, these has been expanded and explained better through various judgments. So, it has been held by the Gujarat High Court that a Hindu woman who converts to Islam after marrying a Muslim man does not lose her inheritance rights in her father's ancestral property. She will be equally entitled in the property even after converting to Islam as she was entitled before her conversion. It's also important to note that the Caste Disability Removal Act of 1850 states very clearly that change in a religion does not result into forfeiture of property and exclusion of inheritance. As per Section 2 of the Hindu Succession Act, the Act would apply to all persons whose parents are Hindus. So it doesn't matter whether the child has converted to another religion or not. Thereafter, in the case of the Bombay High Court has also held that very category that a Hindu who converted to other religion is not disqualified to claim the property of his father who died intestate, that is, without a will. As per Section 4 of the Hindu Succession Act, any other law immediately before the commencement of the Act will cease to apply to Hindus insofar as it's inconsistent with the provisions of the Act. Since all other inconsistent laws are abolished, except for the Caste Disabilities Removal Act, hence it will apply over and above the Succession Act. Also, Section 26 of the Act has no impact on the convert's right to inherit property from the Hindu relative. It only disqualifies the children born after conversion and their descendants, and not the convert himself or herself, which basically means that if an individual has converted to another religion, they are entitled to inherit their parents' property. However, their children, the convertees' children, will not be entitled to inherit any property from their relatives, ancestors. Now, we've discussed the rules of succession when it comes to conversion. However, what are the rules of succession when it comes to illegitimate children? Now, it's very important to know that the Supreme Court has held that the relationship between the parents may not be sanctioned by the law, but the birth of a child in such relationship has to be viewed independently of the relationship of the parents. A child born in such a relationship is innocent and entitled to all the rights which are given to other children born in a valid marriage. This is the crux of Section 16, subsection 3 of Hindu Succession 2005 Amendment Act, which basically, hence, any child who is born out of the wedlock, out of the wedlock, or is considered to be an illegitimate child, will have the same right as that of a child who is born in a valid marriage. It's also important to know that under Section 16, subsection 1 and Section 16, subsection 2, it's been expressly declared that children born in a void or voidable marriage as per Hindu Marriage Act will be considered to be illegitimate. If they were declared legitimate, they cannot be discriminated against, and they will be on par with other legitimate children and be entitled to all the rights in the property of their parents, both self-acquired as well as ancestral. The prohibition contained in Section 16, subsection 3 will apply to such children with respect to the property of any person other than their parents. It's very interesting to know that the legislature has advisedly used the word property and has not qualified it either with self-acquired property or ancestral property. Hence, the illegitimate children are entitled to the ancestral property as well as self-acquired property of the parents.
So I think if we actually express this judgment a little bit further, you see, even a live-in relationship child.
So when an
So when an
illegitimate
illegitimate child also get this right,
even live-in
the
relationship
child will also get the same right. So, because the basic crux of the Honorable Supreme Court judgment is children are not illegitimate. The relationship between the male and female is illegitimate. So, बच्चा है वही legitimate नहीं है. Illegitimate है वो सिर्फ relationship. Because of this, the child cannot suffer. Ancestral property or it is self-acquired property, वो सारी properties का हक उसी हिसाब से होगा as if he was born out of a legitimate marriage. ये बड़ी इंपॉर्टेंट समझने वाली है. आपको पता है ऑनरेबल सुप्रीम कोर्ट ने इवन लिव इन रिलेशनशिप में ये भी कहा, जजमेंट जो हमारे सामने नहीं है, कि इवन लिव इन रिलेशनशिप सपोज द फीमेल left high and dry after the live in relationship, then like any other woman entitled to maintain from her husband, she will also be entitled to maintenance. एक और बड़ा जजमेंट ऑनरेबल सुप्रीम कोर्ट लॉ ऑफ सक्सेशन पे बड़ा है कि even parents are also entitled to maintenance. जो पेरेंट आपको पाला है, suppose you want to leave them high and dry because they have no right on your property, you might have done self-property, but you were ultimately created by those parents only, looked after, and you actually came into being on their contribution. That is why Honorable Supreme Court has said in one very noting judgment that it is duty of every single child to look after their parents. लीगल रिस्पॉन्सिबिलिटी है और आप अपने पेरेंट्स को अपने घर से बाहर नहीं निकाल सकते. इस बात को समझ लेना जरूरी है. ये सारी बातें मैं सिर्फ आपके सामने, पूरे समाज के सामने इसलिए रख रहा हूं कि हम चार्टर्ड अकाउंटेंट से हर आदमी कंसल्ट करने बारे में कि सर क्या हो सकता है, क्या है. वकीलों के पास तो आदमी बहुत बाद में जाता है, पर अगर उसे अपने हकों का अब क्या उसके साथ हो सकता है उसका आइडिया ठीक होगा, क्योंकि जब बैलेंस शीट फाइनल होती है, इनकम टैक्स की रिटर्न फाइनल होती है, उसमें बहुत सारी चर्चा होती है. उस चर्चा के दौरान फॉर्मल इनफॉर्मल कई तरह की एडवाइस क्लाइंट्स आपसे मांगेंगे. तो ये जो चीजें मैं आपसे आज शेयर कर रहा हूं, दे आर गोइंग टू बी वेरी वेरी हैंडी फॉर ईच वन ऑफ अस. फर्दर नन्या जी, गो अहेड, गो टू द नेक्स्ट प्लीज. We testamentary succession पढ़ाइए.
Like, so as we already discussed right now, as also has been held by the Supreme Court, that Section 30 of the Hindu Succession Act makes it very clear that Hindu testator, that is Hindu male or female, can dispose of their property dispose of any property which is capable of being disposed of by him by will or either other testamentary disposition in accordance with the Indian Succession Act. The position which was prior to the 2005 amendment, when a Hindu dies after the male Hindu dies after the commencement of the Hindu Succession Act, leaving at the time of his death an interest in the Mitakshara Kopasniri property, his interest in the property will devolve by survivorship upon the surviving members of the Kopasniri. It's very important to make the difference between these two points put forth before you. The position prior to the 2005 amendment was only clearly meant that when a Hindu male dies after the commencement of the act, and if he has any interest in the Kopasniri property, then his interest will devolve upon the surviving members of the Kopasniri. However, post the 2005 amendment, it's clear that a Hindu testator, which means a Hindu male or a Hindu female, can dispose of any property, which is their share in even the Kopasniri property by either will or any other testamentary disposition as per Indian Succession Act.
Please go to the next.
I think we have actually now already covered the major portion of Hindu Succession Act, and now with the process of Indian Succession Act, we will be going to the field of how a will is, what a will be doing. So I think we'll start with this. If there are any questions in the Hindu succession law, if anybody has questions, and if organizers want us to really handle them now, we can handle them now, or we can handle at the end. It is for the organizers to decide. If no information comes from organizers, then I think I'll assume that we can.
Sir, we'll take questions in the...
माविया जी, अगर आपके questions हैं, कोई प्रश्न है, सुनील जी, तो आप हमसे अभी स्टेज पर भी पूछ सकते हैं, which relates to Hindu laws, Hindu succession.
Sir, shall we take the questions in the end?
Your voice is not coming, Mahavir ji. You're on mute, it appears.
Sir, am I audible now?
Yes, please.
Please.
Sir, shall we take the questions in the end?
Audible है? सुन रहे? सुन, ठीक है, बोलिए please.
Sir, shall we take the questions in the end?
So, okay. Then I think I'll request, Akhilesh, will you like to take up this portion?
Yes, of course.
We are there to supplement. Me and Ananya and Chavi, all of us are there to supplement.
Yeah.
Lead the discussion from here.
Yes, please, sir.
Advocate Akhilesh.
Good evening, everyone. Rana, are you showing the PPT or I have to show that? I am audible to everyone?
Yes.
Yeah. Thank you. So now one of the most important thing in the succession planning is the concept of a will. So actually there are lots of things which we have to understand: what is will, how it is executed, how it is drafted, how it is made, what is to be covered, what is not to be covered, where to place it, where to keep it, to whom it should be known, whom to should not known, with whom we have to draft it, whether it is CA, whether it is a lawyer, whether it is someone else, whether it is... There are innumerable questions which is actually related to wills. So now slowly and gradually we will try to learn the best possible thing about the will. So in near future we don't have to face any problem with regards to actually for the will. So now first thing is, what is a will? And who... Okay, the first thing is, what is will? So if we take the basic thing, what is will? A will is a testament legal document designed to tell if... What is will? A will is a testament legal document designed to tell the probate court what to do with your asset at your death. So if we... the legal definition is maybe a bit tricky, but even in simple language we want to understand what is will. So basically will is a standing order by the probate court to how your asset, how your estate will be divided after your death. It is basically a legal document which have a great value after the death of the person who is making the will. And the second point is, a will must comply with the law in writing. And then can we get to the first slide? Just slide back to this. So will is basically a legal document by which the testator of the will is capable of being, distribute its asset, which is all, earned over a period of time, over a period of whole life. How his asset, his state, his any asset which he want to, distribute to any person is being capable through a legal document which is called a will. And now the concern is who can who can have a will. So the second important question is, who can have a will? So the answer to this question is, every individual who is a major of a sound mind and with a free consent is capable of making a will. So if you reading this thing, then we can easily deduce that every person who is capable of making a contract as per Indian contract is also able to, make our will. So what are the basic, important consideration which are essential for a will are: first is bequest of specific asset, example painting, art, jewelry, and securities. Second point is beneficiary waterfall. Third is choice of executor and witness. Fourth is process of applying probate and letter of administration. Actually, these 4 points are itself a very, very detailed discussion topic. If we take one by one each and every point and explain a bit, which the more it is possible. The first thing is what we can bequeath via bill. So the first point, we can do anything. We can, the first thing what we can bequeath via bill is the will must set out. I don't know. Can you turn the first slide on? First slide. Yes. So what we can bequeath via will is, bequeath is a specific asset like painting, art, jewelry, security. That means the thing which is actually in existence can only be bequeathed via will. It's not like that we can, bequeath something which is not into existence. So this is the concern which actually the person who is making its will shall be specific about the each and every asset, whether it's a movable, immovable, or XYZ. But that asset should be specific. And the next point is choice of beneficiary waterfall is not a big concern here, but the third point is choice of executor and witness. See, this is one of the most important aspect while making the will, that who will be the executor of your will after your death. So these persons shall be, before selecting any person, a detailed analysis should be done, and who shall be the witness. This is also one of the most important question while making the will, because generally sometimes it happens like the person make the witness to their friends or someone with their same age group, and the concern is before their death their witness has been dead. So their witness died before their death. So before selecting any witness, you should be very careful about to whom you make the witness, so that they can in near future, if your will is challenged, then they are there to justify the testament. And the fourth point is process of applying probate and letter of administration. This portion will come in, in coming slides. Can you please turn? Now the practical consideration of a will. The first point is the will must set out the intention of the testator to bequeath his estate unambiguously. The last word which is written in the first line is very important for a will. So what generally people make will of a 50 pages, 10 pages, 20 pages, 30 pages. The pages in the will, I don't think make any difference. Whatever it is written in the will should be unambiguous. This is the most important part of a will. A will should be very clear and should set out the intention of testator like that anyone who read that will should have a clear image what the testator want to bequeath. So unambiguity is the core of any will. If a will is unclear, because this is a legal document which actually come into execution after the death of a person who actually made it. So the clarity in the will should be, at most importance while drafting a will. So the will must set out the intention of testator. So it is very necessary for the testator to know what actually he or she want to be. So if the position in her or his mind is clear, then only it is easy for the testator to make his or her will. Now second point is will can be revoked at any time during the lifetime of testator. So this point is also very important, because generally people have misconception about that the wills has been once made cannot be revoked or cannot be cancelled. But actually the situation is, if a will is made, then that will can only that will can be revoked, but only during the lifetime of a testator. Once the testator died, the last will of the testator will be the final will of that person. So you can revoke or change your will during your lifetime any number of time, as much as you want. But the concern is there are some catch which we will discuss later on. Now the third point is a will is not required to be stamped. So there is also some misconception in the public at large that the will should be made on a stamp paper, it should be registered. So these all the things are only a hearsay thing, but in legal parlance, will is not required to be stamped at all. Will can be made on a mere paper, on a blank paper, on a white paper, on a blue paper, on whatever paper you want to. There is no requirement of any stamp duty or any registration. Will can be made anytime, anywhere, at any place. The basic necessity which is actually required for a will to be, valid will, we'll discuss later on. But there is no requirement for any stamp duty or any registration to be a will, to be a legal valid will. The fourth stamp, there is no requirement for stamp, there is no requirement for registration. A will need not to be printed on a legal paper. It may be printed on a plain paper as well. There is no such thing like will to be print. Will is to be printed on any paper. We can even write a will. We can even, if you want to print on any paper of any dimension, any quality, anything, there is no specification mentioned anywhere for the, size, quality, or anything related to that. The last aspect, which is international will probated outside India, can be enforced in India subject to an application made to relevant court seeking letter of administration for Indian state mentioned in the will. So this concept we will deal in detail later on in this presentation only. But for the brief, I will do the introduction. For brief, I will tell you, like, if there is a will made by a person who is outside India, international will probated outside India, the country can enforce in India subject to application. See, the concern is generally what happens is a will is made outside India and there is a property situated in India, and we want to get that execution of that will in India. So in that case, we have to take the permission from the court of a particular jurisdiction in whose jurisdiction that particular state is false. So we have to make an application to the concerned court for the probation of that will and do all the necessary aspects which are relevant for execution or letter of administration for that particular state in India. Can we go to the next slide? Ananya? Now, this point is actually more of a practical importance rather than a theoretical or a presentation point of view. What are the advantages and disadvantages of a will? This is actually purely based on the need of a testator. It's purely depend whether the registration of will is beneficial to the testator, or it may be a disadvantage for him or her. It's purely depend on person to person. But in general, what are the disadvantages and advantages we are discussing here? The advantages of will are evidence of execution by a testator with respect to mental state and health of testator, evidence of execution with free will without any coercion or influences, safe custody of will and certified copy can be obtained at any time, litigation relating to existing genuinity and forgery reduces. So one by one we try to explain the things. The first thing which is mentioned here is evidence of execution by the testator. See, basically when we get the registration of will done, generally practically the process follow in the sub-register office, where we don't have to, we have to sign in front of the person. So this evidence of execution by the testator is already there on the record of a sub-register office. So the first thing is basically a creation of evidence by the execution. It's basically evidence of execution by the testator at sub-register office. So registration of will has advantage that it will become an evidence of execution by the testator. The second point is with respect to the mental state and health of testator. So at the time of registration, whether a person is mentally stable, how is his health, क्या किसी ने जबरदस्ती तो उसका अंगूठा नहीं लगवा लिया उस will के ऊपर, or something like that. These all the scenario will cut down if a will get registered in the sub-register office regarding their mental strength, that the person who is executing or making this will is absolutely fine. And second thing, he is being capable of making this will. So these are something which actually at the time of registration get corroborated. The third point is evidence of execution with free will without any coercion or influences. Might be the case there are some young sons who forces their father to sign a will and then they get it registered in the sub-register office. But in case of a registered will in the sub-register office, this concept, this point also to get clear that there is no coercion or undue influence on the person who is actually making this will. Then the fourth point is safe custody of will and certified copy can be obtained at any time. Once we register our will to the concerned sub-registrar office, one copy we get from them, and one copy they keep it for a safe custody. In near future, if anyone want to get them as a evidence or in a court of law or for any other purpose, we can get the certified copy by paying very small amount of fee to the sub-registrar office and get the copy of a will. And the last point, which is very important, is litigation relating to existence, genuinity, forgery reduces. Yeah, this is important because a registered will has less chance as compared to a unregistered will of a forgery, genuinity, and existence. So these are some advantages if we get the registration of will. And now coming to what are the disadvantages of a will if we don't get it registered. Sorry, what are the disadvantages if we get a will registered? So now come to that point. There are some disadvantages also which is there in case of a registration of will, which maybe not apply to every cases, but in general legal parlance these things are there. The first point which is there is difficult to amend or withdraw or revoke to be registered again. So this point is all about, like, if a first your will is registered, then if you want to make any changes to that, then in that scenario your amended will shall also be get registered, then only it shall revoke the earlier will. Otherwise there is no change in your registered will if you don't get it registered your amended thing. The second point is a last will which is not registered may be questioned by a pre-executed will as a genuine. Yeah, this is generally we see in day-to-day affair, like if there is a registered will and there is one unregistered will, in that case a registered will is always given preference over an unregistered will, whether an unregistered will is actually executed later on. To prove that thing in our court of law is very difficult as compared to prove the genuinity of a registered will. And the third point, which is actually most important for a high net worth client and all, those who actually don't want to make their life, public, they don't want to, get exposed what actually they are, implementing or executing about their state, that is privacy and confidentiality may be compromised. Generally, what happens is very easy for us to get any will from a sub-register office or something like that. But people of a high net worth and something like that, they don't want actually to get their thing to be get leaked. So this might also be a disadvantage if we get our will registered. But as a advisor or as a person of legal background, we generally recommend to get your will registered as in place of an unregistered will. Can we get to the next slide? Now the question is, can a will address all the issue and various kind of property right? So this is another question कि क्या एक will से सारी problem का solution हो सकता है? And an answer is absolutely no. Will is not the answer of every problem which a succession have, but will is, you may say that will is answer of many problem, but not the all. So can a will address all the issue and various kind of property right? First is freehold, leasehold. Second is joint ownership. Third is either or survivor. Fourth is tenancy, license or right, partnership right, management right, right as a trustee of a trust, goodwill, intellectual property right, and so on. Yeah, we can address each and every issue via will. These are some example of few rights which are generally we transfer by way of a will. Now can we go to the next slide? Now this is most important thing under will, that is restriction on transfer in case of a will. These are few restrictions which we have to keep in mind while making our will. And this is most important, and generally people don't, while making their will, they put anything under the sky, but later on they, figure out that this is, actually not possible, or it is a void will or something like that, that someone challenge it and they are now facing the issue in actually proving the genuinity, etc. and etc. So these are the few restrictions on transfer in case of a will. The first is mentioned in section 112, that is bequeathed to a person by particular description who is not in existence at testator death. So this is the most important point in what we restriction on in case of a transfer of will, that this case is actually tells us about we cannot bequeath anything who is not in actually existence at the time of a death. So if you take an example, what it actually want to tell us, like say a father want to bequeath something to his grandson or granddaughter who is not actually in existence at the time of his death, then in that case, if we mention anything about him or her regarding any bequeath, that will not be valid. The second point is bequeath to a person not in existence as a subject to prior bequeath. This is actually related to the first point. Any bequeath made to a person not in existence as testator death subject to prior bequeath. That means if any bequeath is made to someone and that person is also not in existence, then in that case both the bequeaths will be invalid or not genuine in case of a prior bequeath. If first is failed, then another is also consequently get failed. The third is made to create perpetuity. Generally, what is the concept of perpetuity? Is generally in legal parlance, what we say is like the property should not be controlled via death hand for a very long period of time or for a period which is actually in perpetuity. Let's suppose a person is dying and he says that after my death, this property will go to X and thereafter to Y and thereafter to Z and thereafter to K and thereafter to A and B and C. If any bequeathing of this type, like a person who is actually dying and controlling that property for a long period of time, so this is also restriction under the will. You cannot do such things. Fourth is bequeath to a class, some of whom may come under rule in section 113 and 114. It's same telling about the above thing. Bequeath to take effect on failure of prior bequeath. That means if let's suppose a person has bequeathed something to someone, but that person to whom it is bequeathed has not came or it's failed. So in that case also the next who have to come into the picture will also get failed. So if a prior bequeath is failed, then the earlier subsequent bequeath is also get failed if it is related to prior one. So if you want to add anything, you can add here.
Akhilesh, I is बच्चा जो है मान लिया it is take birth, but it is conceived. That is a person which is in existence, because as per Hindu mythology as well as otherwise, a child is in existence if he is unborn. So you can always bequeath by way of a will to an unborn child, but you cannot say maybe tomorrow my grandson or the great grandson, neither the son is born nor the great grandson is born. So that will give you anything. So because that is what that will be treated as illegal or invalid, and according impact your the entire will structure. So these are all what he actually explained is perpetuity. You can't really say perpetuity. For example, you say that this will go to my wife. After the wife, it will go to the son. After the son, it will go to the grandson. After the great grandson, it will go to his wife. Then after it will go to his son, and like that. If you keep on controlling, तो आप ये नहीं कर सकते. That means what you're trying to do is you're trying to give limited right at every level. So whenever you give a will, of course you have a right. You may give a right during the lifetime, or you may give a complete absolute right to the survivor. Options are there with you, but that you can't do in perpetuity. That people in between will have no right at all, whatever you are succeeding, and it will keep on going, automatic shuttle go to them. That is not the purpose of the Indian Succession Act 1920. क्योंकि आप जनरेशन को हक जरूरी है, चाहे वो हक लिमिटेड है. जैसे मैंने बताया, आपने अगर मान लिया अपनी वाइफ के लिए मान लिया आपने टेस्टामेंटरी सक्सेशन की, और आपने कहा कि she can utilize that property during her life, but she cannot dispose it off. For example, you want to keep this kind of restriction, that should be possible. But she will have full right to take rent from that property and other things, or maybe you may permit her, she can completely free whatever she wants to do. She cannot particular लॉस की तरफ नहीं जाना चाहिए. So that also you can always say कि भाई प्रॉपर्टी जाएगी तो मिसेस सो एंड सो के पास, maybe your wife or maybe even a third lady, but then after her death it will come back, it will go to maybe possibly to and so. ये सारे restriction पर perpetuity नहीं करते. We'll go to the next slide please. Every will shall be revoked by the marriage of the maker. ये सेक्शन 6 कहते हैं आपने जो शादी से पहले विल की वो ऑटोमेटिकली रिवोक हो गई ऑन द मैरिज ऑफ द पर्सन हु हैज एक्चुअली एग्जीक्यूटेड द विल. तो लड़की ने अपनी पहले विल एग्जीक्यूट की, लड़के ने अपनी शादी से पहले विल एग्जीक्यूट की, बिकॉज द सिचुएशंस चेंजेस. दैट इज व्हाट द सेक्शन 69 स्पेसिफिकली प्रोवाइड. ये बहुत सारी चीजें जो पता नहीं होती है हमें. No unprivileged will or codicil nor any part thereof shall be revoked otherwise than by way of marriage, another will or codicil, or by some writing declaration and intention to revoke the same and execute in the same manner in which the unprivileged will is hereinbefore required to be executed. देखिए ये कई तरीके हैं जिनसे आप विल को अपनी को खत्म कर सकते हैं. Unprivileged will is only a type of a will. Most of the will are unprivileged wills. What is a privileged will? What unprivileged will? I am not going to. So any will or codicil. Codicil is an amendment of a will is called codicil. So either a will or an amendment to a will which is codicil, you can revoke it either in part or in full, right? By writing a declaration. आप एक declaration दीजिए कि भाई ये हिस्सा clause A और clause B will not be having any impact hereafter. उसकी जगह A will be replaced by this or B will be replaced by this, or you can completely cancel. Doing the replacement will amount to codicil. दूसरा रास्ता है आपने बिल बना दी, साइन कर दी. सपोज यू बर्न द, आपने फाड़ दी, आपने जली या डिस्ट्रॉय कर टेस्टेटर ने इन द प्रेजेंस ऑफ सम अदर पर्सन, और साथ साथ उसने ये भी कहा कि हाँ भी ये विल मैंने रिवोक कर दिया. Suppose he issues a letter or he openly declare that this will is destroy. He can burn, he can tear, or he can otherwise destroy. If there are adequate evidence is available that he burnt it, tear it, or destroyed it, even if it is a registered will, even then it will get revoked, provided there is evidence that he has burned it with the intention of revoking. That intention of revoking, of course, will have to be proven. Go to the next. आप लेना चाहेंगे प्लीज. Go ahead, Akhilesh. Go ahead.
Yeah, sir. Thank you so much, sir. Now coming to this is also one of the practical aspect, like a role of an executor of a will. This is actually the most important part, because the concern is when at the time of making will, we don't think what will happen in coming future at the time of execution of this will, because generally people what at the time of making will, they don't perceive the situation what is going to be happen in near future. So the execution part of the will is most important in actual effectiveness of a particular will. So this concept is all about role of an executor of a will. So executor is a person who actually executes the will or the intention of the testator. Whatever written in that will, it is the responsibility or onus or duty of the executor to actually make the things as much as possible as per the intention of the testator. So there are few steps which are written regarding the role of an executor of a will. So it is very important while selecting the executor of a will, because these are the things which he or she may have to perform. So you shall be very careful before selecting any executor. So the first thing is to obtain a probate or a letter of administration. Both the concept is different. First is to obtain a probate or a letter of administration. the requirement to obtain a probate, and second is a letter of administration is generally like, if in case if our will is not registered, then we will go for probate. So what in that scenario what happen is, if your will is not registered and that is your final or last will, people the I mean the for effective execution of that will, the banks or any other person or the revenue authority generally asks for a probate of that particular will. So we apply to the court to get the probation of that will, unregistered will. And in case of a registered will, they ask for a letter of administration for the executor, because there is a name already written in the will that this person is the executor. And to get that person the right to get these things done, he need a permission or maybe some authority from the court that yes, he is the person who have the right to actually implement the this will. So there might be the case that authority or person or bank or security, they may ask for letter of administration for the concerned executor. So this is the first thing which the executor have to perform to get the effectiveness for the will. Second thing is to look after and manage the property under the will. There might be the case like a person has made a will and he might have put some condition like that this property will go to my son only after 18 years or only after 25 years or only after a particular point of time on the marriage on something like that, or some there might be n number of things which can be written in the will. So it is a person who is executor who will manage till the time the property is actually devolved to a concerned beneficiary who is written in the will. He is the executor who will manage the property, who will look after the property, who will take care of each and everything of a testator during the period of a death of testator till the actual disposition of a property to the beneficiary. So it is also a very important role for him. Third is to deal or dispose of the property in a manner desired or required by the will of a testator. So this is also important. Like there might be the case that in the will itself, it is very clearly written that how the property to be dealt with. Like let's suppose there is a immovable property of a testator. He wants that after my death, this property should be sold and the amount which is received from the sale, that should be equally divided among my 4 sons. There might be the case that he left upon the executor to divide his property equally among all the 4 sons or all the 4 beneficiaries. So the executor is the person who will decide the best possible scenario if there is nothing written in the will, how to dispose or how to actually completely honor the intention of a testator. So this is also the role of an executor. Now fourth thing, to make inventory and account of estate. This is a general thing generally which executor perform. The fifth is to incur expenses on medical and other services taken by testator in 3 months immediately before death. To incur expenses on medical and other services taken by testator in 3 months immediately before death. See, these are some roles which actually may or may not be given to the executor, but it's always advisable to give. The next is to incur funeral expenses. Yeah, this is the most important thing which is actually definitely there in the will, that after death, it is the executor who will pay the expenses out of the estate of a testator for any funeral expenses. And the next point is the most important of all of this, to discharge that due at the time of death of a testator. Generally, people were only concerned about the estate. People generally don't look for his death. If there is any liability on that person at the time of a death, it is the executor who will take care of this to discharge all the debt from the estate of a testator before distribution of any asset, any estate or anything which is for the benefit of the beneficiary. And last is to pay legacy only after indemnification of a contingent liability. Contingent liability cannot be defined what may be the contingent liability, but it can be say like any liability which is cannot be foresee or cannot be we can presume what it is to be, that should also be taken into consideration before distribution of any legacy, any benefit from the estate of a testator. Before distribution of anything, the executor will consider each and everything.
यहाँ एक मिनट अखिलेश मैं थोड़ा सा ऐड करना चाहूंगा.
Yeah, please sir, please.
I only want to add here, this person executor has to be a person who is the most trustworthy person known to the person who is actually the testator. टेस्टेटर मतलब जिसकी एसेट्स के लिए उसे टेस्टेटर बोल रहे हैं. He is executing the will does not mean that he becomes executor. Let us not confuse between the person who is writing the executor. Executor is a person who is going to administrate the property in question after the death of the person who has written the will. Will is of Mr. A. He should select Mr. B. That Mr. B who is going to take after कि उसकी प्रॉपर्टी को कैसे देखभाल होगी, उसकी कैसे किस किस को जाएगी. फॉर एग्जाम्पल अगर एक मकान में से मान लिया 10% एक को जाना है, 20 एक को जाना है, 30% एक को जाना है, 5% एक को जाना है, किसी को खाली एजुकेशन का खर्चा देना है, ऐसा कुछ भी हो सकता है. सो वो सब देखिए एग्जीक्यूटर का है. तो एक तो एग्जीक्यूटर अपॉइंट करें, उसके रेम्यूनरेशन की करें, उसके खर्चे की व्यवस्था करें में. और नॉर्मली एग्जीक्यूटर की कंसेंट आपको एडवांस में लेनी चाहिए, क्योंकि हमारा एक्सपीरियंस से कहता है कि आपने किसी का भी नाम एग्जीक्यूटर में, आपकी डेथ के बाद, डेथ से पहले तो आपको जानता है पहचानता है, डेथ के बाद कहेगा झगड़े में नहीं पड़ता, मेरे को मत डालो इसमें. फिर वो एग्जीक्यूटर तो फिर कोर्ट के हाथ में आ जाएगा, वो किसको अपॉइंट करता. इसलिए एग्जीक्यूटर से पहले आप कंसेंट लें, कंसेंट लेके उसका रेम्यूनरेशन, उसकी कॉस्ट भी तय करें. और अगर आपका कोई रिश्तेदार अच्छा ऐसा है कि जो इस लायक है, आपका दामाद है, आपका बेटा है, आपका चाचा जी हैं, स्पेशली जैसा बताया अखिलेश ने, जिस पे भी आपको ट्रस्ट है. मैंने शुरू में कहा था लव मनी एंड कंट्रोल. तो आपका दिल से दिमाग से फैसला करिए कि कौन आदमी आपका ट्रस्ट उसका ये इस बात का कि हाँ भी वो एग्जीक्यूट करेगा विल आपके बिहाफ पर. उसे तय करिए कि अगर उसको रेम्यूनरेशन उसे चाहिए, एंड वन ऑफ द पीपल बेनिफिशियरी ऑफ योर विल कुड आल्सो बी द एग्जीक्यूटर. ऐसा नहीं कि वो नहीं हो. मान लिया इट इज गोइंग टू डॉटर, योर सन इन लॉ, द पीपल. तो हो सकता है आप अपनी डॉटर या सन में से किसी को एडमिनिस्ट्रेटर बनाना चाहें, अपना एग्जीक्यूटर बनाना चाहें उसका विल का. Even chartered accountants can also provide this service of being an executor of a will, that is also against a fee, or an advocate you can appoint. हमने देखा है, मेरे को फेमस फिल्म सीता और गीता, आपने सब सीता और गीता फिल्म हेमा मालिनी साहब आते हैं और वो चाची हर बार जो सीता गीता की चाची जी हर बार वो झपट लेते हो. ऐसे लोगों ने फिल्म देखी है. दैट इज ओनली एन इंडिकेशन दैट strong enough and is able to ensure it goes to the right beneficiary. I think that is what only I am trying to indicate. तो executor ध्यान से अपॉइंट करे, समझदार हो, होशियार हो, और इंश्योर कर सके कि बेनिफिशियरी के पास ही जाए, और बेईमान ना हो. उसके ट्रस्टवर्दी होना बहुत जरूरी है. एंड इट इज पॉसिबल कि आपने इसको एग्जीक्यूटर बनाया और आपके जाने से पहले या तो वो सड़क से हार गए, या फिर वही खुद ही इनकेपेबल हो गए, किसी भी वजह से तबीयत खराब हो गई, वजह हो सकती है. तो हमेशा एक ऑल्टरनेट की व्यवस्था जरूर करनी चाहिए, मिनिमम वन ऑल्टरनेट. तो एक ऑल्टरनेटिव हो कि हाँ भी किस परिस्थिति में अगर मिस्टर ए ना कर पाए तो मिस्टर ए की जगह मिस्टर बी अपॉइंट हो जाएंगे, ऑटोमेटिकली हो जाएंगे. किस परिस्थिति में हो जाएंगे वो बात है. फाइन, वी गो टू द नेक्स्ट प्लीज. When I see Maria, I think
sir, considering the time constraint,
going towards the end of the workshop, it appears. कितना time?
So it's 5:54. I think the time is up.
5:54. तो I think I will give. I will stop myself here because we have to hear Shri Chatta and also answer the questions. जी हम आपको जरूर सुनना चाहते हैं, बहुत जरूरी. बाकी हम अगले सेशन में करेंगे. We'll keep on coming and talking to present here for as long as you really want. We are here to share our knowledge.
हेलो हेलो.
Yes, sir, you are audible.
हाँ, जैसा व्यक्ति बताओ कि क्या एक सिंगल पर्सन कैन बी ए कर्ता ऑफ 3 HUF?
आवाज नहीं आई सर.
हेलो, एक कर्ता 3 HUF का हो सकता है क्या? एक पर्सन
3 HUF का एक कर्ता?
हाँ जी, एक पर्सन. ग्रैंडफादर की HUF चल रही है, फादर की HUF चल रही है और मेरी पर्सनल HUF चल रही है.
तो ब्रदर और फादर नहीं है तो उनकी HUF अलग चल रही है.
वो पुरानी चल रही है क्योंकि एक ही वो है
मैंने अभी बताया
एक ही संबंध।
at the time of every death, legally speaking, of every death, there is a notional complete partition. If the father is alive or the grandfather is alive, or it is of course is possible. Hello, one thing of course is possible that suppose father is not alive, but your brothers are there, sisters are there, and you become the karta on his behalf. That is possible.
single child,
Suppose your grandfather is there, single child.
single child. No,
So there is
I don't even. I
So
don't
there is
see any
no-
possibility that you have a single child. Then I think it is possibly somebody is misusing the process of law. There's nothing called fair. Only single is there with a joint family.
क्योंकि उनके
ग्रैंडफादर की डेथ पे फादर के पास आ गया,
फादर भी
ग्रैंडफादर की
सिंगल
डेथ
थे,
पे फादर के पास आ गया.
फादर भी सिंगल थे, उनका भी कोई वो भाई नहीं था.
Sir, there is no restriction in law.
टीम नहीं चल सकती है सर.
हाँ?
Sir, but there is no restriction in law, I think.
No, there is no restriction in law, but there is, law is silent about HUF. Please understand, Akhilesh ji. लॉ इस बारे में साइलेंट है, इसीलिए लोग सब तरीके से काम करते रहते हैं और चला भी रहे हैं लोग प्रैक्टिकली समाज में. ऋषि जी बिल्कुल बड़ी सही एग्जांपल दी उन्होंने कि वो अलग से वो एक है दूसरे अलग तीसरे अलग चला रहे हैं. बट इन माय आई कैन ओनली गिव प्रोफेशनल व्यू if it's a single grandfather, single father, and you are a single son. The question of having multiple HUF cannot really arise if the father and father both are not alive.
इसको देखना, थोड़ा चेक करो. इसको लगता है कि है, ये वैलिड है, लीगल है. इसको थोड़ा सा
मैं तो अभी देखो आपके सामने सुप्रीम कोर्ट का जजमेंट बताया. जजमेंट ने कहा कि आप डेथ के टाइम पे कंप्लीटली बांट दो. मैं कहा था आपको लास्ट जजमेंट.
ओके,
तो आप उस जजमेंट के तहत ही इंटरप्रेट करेंगे अल्टीमेटली, बिकॉज इट इज वेरी क्लियरली रिटन इन द लॉ ऑन द ओकेजन ऑफ एवरी डेथ there is going to be complete partition of the HUF. So there is a feeling the lot of learned people talked and consulted. उनका व्यू बड़ा क्लियर है इसके बारे में कि जिस भी दिन डेथ होगी, मान ले फादर की डेथ हुई, तो फादर की HUF उस दिन खत्म हो जाएगी और वो लीव्स में उनके जो हकदार हैं उनमें बढ़ जाएगा.
अच्छा, एक चीज और बताओ.
हाँ, ये हो सकता है कि फादर की HUF अगर आप करना चाहें और फादर ने अपने लाइफ टाइम के भी मेरी HUF जो है ये फैमिली प्रॉपर्टी, ये मिस्टर and will look after the other members of the family, including his mother, including his sister, and so on to the family member, and will not divide it. Then I still see a possibility that HUF can continue. But we say there is family, mother भी नहीं है, वो कैसी HUF बनेगी फादर की? सब बढ़ जाएगा. कानून के हिसाब से, सुप्रीम कोर्ट जजमेंट के हिसाब से सब कुछ बढ़ जाएगा. बट अगर फादर ने अपनी टेस्टेटरी डॉक्यूमेंट में लिख दिया कि भाई ये HUF की प्रॉपर्टी रहेगी मेरी डेथ के बाद ही, इट विल बी अ फैमिली ऑफ सच फैमिली, देन ओनली इट कैन क्रिएट अ सेपरेट फैमिली सेक्टर.
ओके,
तो इसलिए विल की ड्राफ्टिंग जरूरी है. जो भी आदमी हो रही है, whosoever is expected to die, अगर आप उसके HUF को कंटिन्यू करना चाहते हैं.
नहीं, विल में
अखिलेश आप ऐड करना चाहते हैं कुछ?
Yes, sir. Basically, see, considering, sir,
पता नहीं है.
Rishi, I am giving a chance to Akhilesh and Ananya to comment what I am saying.
Okay.
sir, I personally believe that it is possible कि a person can be a karta in more than 2 HUF. Let's say a scenario, sir, like a family. If a father is died, after that amendment, 2015 amendment, it is possible, I believe that, because let's say there is a family and father is died and the elder son will become the karta in his father HUF, and now the daughter and woman is also the co-partner in a HUF. So his family, that is he, his wife, his daughter, can make another HUF which is of him, and he can be the karta in his HUF also. So it both at the same time, he is a karta in the father HUF and he is a karta in his HUF. So there is no restriction in law, and also as per law after 2015, it is per se seems valid and legal. He can be a karta in more than multiple HUF if the scenario and other circumstances allow him to do that.
Ananya, you want to supplement, please?
So I agree with.
Akhilesh.
Yes. Okay. So. I believe Akhilesh's view is correct in this. Correct in this aspect because as actually stated clearly that the karta is actually the eldest member, surviving member of the family, and in case the father is died, the next karta of that the next person in line would be the son in the instant case will become the karta. Once the person gets married, they will start their they have the liberty to start their own HUF. So for sure, for two cases, for an individual can be the karta for the two HUF at least.
But the only thing,
The only thing which I would like to supplement is that you definitely need some more people to have an HUF. There is no family of a single person. That is already held by several courts. कि भाई आपकी family तो होनी चाहिए. Family more than one person. And I think there are certain cases on both sides where say a child is also necessary for being a family. Only husband wife do not form a family. You definitely need a child to have a family. ये पर दूसरी तरफ अपोजिट जजमेंट जो कहते हैं हस्बैंड वाइफ की भी फैमिली हो सकती है, तो जजमेंट दोनों तरफ है. और मुझे ऐसा लगता है कि इसमें हमें खास 2005 के अमेंडमेंट के बाद जहां पर उन्होंने मैंडेट कर दिया कि आपको टेस्टामेंट करनी है, तो ऐसे प्रॉपर्टी चाहिए कि भाई मेरी डेथ के बाद भी HUF मेंटेन रहेगी, सो एंड सो आदमी करता रहेगा, और प्रेजेंट डेट के ये जो बाकी भी मेंबर हैं फैमिली के वो सब इसमें मेंबर रहेंगे. और पर सपोज आपकी डेथ के बाद सिर्फ आपका बेटा ही बचता है, तो फिर वो रह नहीं सकती बिकॉज इट ओनली देयर इज अ सिंगल सक्सेसर. बट आपकी डेथ के बाद अगर मोर देन वन मेंबर है, मदर भी है और वो भी है, तो देन दैट कैन बिकम ए दैट कैन that becomes in that case that can succeed as a family. Father at the date of death very clearly says that the family should continue. That is what I feel. Let us go to the next question, please.
Yes.
HUF अपनी प्रॉपर्टी में गिफ्ट कर सकता है.
आप रिपीट कर सकते हैं सर का कोई, क्योंकि शशि जी की आवाज कट कट के आ रही है.
HUF अपने मेंबर को गिफ्ट कर सकता है को पार्टनर को.
देखिए ये मैंने बताया था कि गिफ्ट नहीं होता, दैट इज अमाउंट टू एलोकेशन ऑफ फंड्स. दैट अमाउंट टू एलोकेशन ऑफ HUF पर सब मेंबर्स का हक है, लेकिन उस हक को एक्सरसाइज करने का हक सिर्फ कर्ता के पास. अप्रिशिएट दिस. वो कर्ता जो है HUF प्रॉपर्टी में से के बेनिफिट के लिए किसी कर सकते. फॉर एग्जाम्पल मैंने बताया कि बच्चों की एजुकेशन के लिए मैरिज के टाइम पे गिफ्ट भी दे सकता है. वो सारे काम HUF में से हो सकते हैं. हम तो नॉर्मली हम सजेस्ट करते हैं कि वे सारे मैरिज एक्सपेंसेस और जितने भी पर्सनल एक्सपेंसेस और ड्राइंग्स हैं वो सब HUF में से करनी चाहिए इंसान को. तो वो उसे सही मैंने में गिफ्ट नहीं बोलते. दैट यू नो आपने देखा 10 में भी वो एग्जाम्प्ट है
एलोकेशन.
Actually, the exemption actually is not even required in 56 because that is their own money. It is only being allocated from the HUF. Family से उन्हें allocate किया गया, और फैमिली में अलजबरा नहीं होता जब तक फैमिली है, किसी को हिस्सा डिफाइंड नहीं है. It is only on the date of death that it is decided what is the ratio, subject to testamentary or non-testamentary succession. ठीक है सर?
ओके ठीक है. ओके थैंक यू.
बताइए माविया जी. We go to the next, yeah, please.
Sir, we have question from Arun Mongaji. He's asking, in real life, do you advise that will should be registered or government authorities honor an unregistered will too to transfer property in the name of heirs?
Okay, ultimately whether the will is registered or it is unregistered, both the will are actually cognizant. But our experience is the proving an unregistered will, whether it was actually executed by them, who has written the will or not, becomes quite. And sometimes you've seen contradictory will come into light because people sometimes, what we have seen is people when the person, even after his death, they actually take his left thumb impression, or when he's dying, when he's on his deathbed, they get signed anything which is an unregistered will. All these kind of allegations will come because we have actually practically seen it कि वो लोग अंगूठा लगवा लाते हैं, लोग साइन करा लेते हैं मरते मरते आदमी के, आदमी अपने होश में भी नहीं होता। जैसा देखिए अखिलेश जी ने समझाया अभी हमें कि अपने होशोहवास में होना आपने प्रूव करना है, उसने अपनी फ्री एक्सरसाइज ऑफ जजमेंट से उस विल को किया, वो भी प्रूव करना है आपने। ये चीजें ऑटोमेटिकली हो जाती है, रजिस्टर्ड विल होती है। रजिस्टर्ड विल में क्योंकि आप जाते हैं सब रजिस्ट्रार के ऑफिस में, वो आपसे पूछते हैं अपनी विल आप करना चाहते हो, आप फ्रीली करते हो, आपकी डेट ऑफ बर्थ क्या है, आपका आधार नंबर क्या है, आपका पैन कार्ड क्या है, वो सारी चीज वेरीफाई करता है। नहीं तो पता लगा मिस्टर चड्डा की विल मिस्टर वर्मा ने कर दी, दस्खत ही तो मारने, कोई भी आदमी दस्खत मार देगा वैसे बना के। ऐसे बहुत सारे लोग कहते हैं दस्खत ही जाली है सर, दस्खत ही एक्चुअल नहीं है, वो तो मिस्टर चड्डा ने किए ही नहीं थे, ये तो मिस्टर वर्मा थे। कोई कह देगा था मिस्टर वर्मा को दस्खत करते हुए, लोग बना लेते हैं। हम तो बल्कि और कहते हैं कि आप विल बनाते हैं, विल लिखते समय एक्सप्लेन करिए विल, और विल जब एक्सप्लेन करें उसकी आप रिकॉर्डिंग भी करिए ताकि पता लगे, उससे कहलवाइए कि आपने समझ लिया विल ठीक से क्या है, और जो भी एग्जीक्यूटर है वो कहे हाँ जी, वो टेस्टेटर है वो कहे हाँ जी मैंने समझ लिया है, सारी बात मुझे अच्छे से समझ में आ गई। और एक बार अगर आप रजिस्टर करा लेते हैं फिर कोई दिक्कत नहीं है, क्योंकि कई बार रजिस्टर कराना पॉसिबल नहीं होता। हमने देखा जैसे अपने हमारे नॉन रेजिडेंट क्लाइंट्स आते हैं, या फिर समटाइम्स द पर्सन इज इन हरी, यार पता नहीं मैं तो कल ही ना सोच से आ जाऊं, तो एक बार आप मेरी विल बना तो दो ही। तो हम उसकी ना वीडियो रिकॉर्डिंग करते हैं और प्रॉपर विटनेसेस करते हैं, और ताकि उसी हिसाब से हम उससे फिर पूछते भी हैं बार बार उस वीडियो रिकॉर्डिंग में कि हाँ भी आपने अपनी मर्जी से इस विल को कर रहे हैं, आप अपने होशोहवास में हैं, और साथ में उसका मेडिकल सर्टिफिकेट भी बनवाते हैं किसी फ्रॉम ए गवर्नमेंट हॉस्पिटल कि हाँ भी उसका दिमाग ठीक चल रहा है, ही इज इन सेंसेस, ही इज ऑफ साउंड माइंड एंड ही इज नॉट डूइंग इट, तो वो एक अलग से सर्टिफिकेट बनवाते हैं। पर एक बार रजिस्टर्ड विल हो तो ऑलमोस्ट फाइनल हो गया। We can go to the next.
We have from
Bansal ji.
He's asking if co-partner create their separate HUF, whether they cease to exist of HUF members.
नहीं ऐसा कुछ नहीं है। देखिए अगर को पार्टनर क्रिएट देयर सेपरेट HUF, देखिए पहली बात तो कोई आदमी अपनी HUF अलग से क्रिएट करने में बड़ा डिफिकल्टी है। उसका सिर्फ दो ही रास्ते हैं HUF कैसे क्रिएट होते हैं। पहले मैं उस प्रश्न का थोड़ा बहुत आंसर देता हूं, क्योंकि खासतौर पे हमारे यंग बच्चों को, यंग साथियों को, चार्टर्ड अकाउंटेंट्स को शायद आइडिया नहीं है भाई HUF क्रिएट कैसे होती है। क्यों शशि जी बता दें थोड़ा बहुत कैसे क्रिएट होती है HUF। तो देखिए HUF जो है मैं एक तरीका तो जैसे अभी हमें अनन्या जी ने कि यू कैन थ्रो योर ओन सेल्फ प्रॉपर्टी इनटू द कॉमन हॉच पॉच, या मेरे ख्याल से अखिलेश ने बताया था आप कॉमन हॉच पॉच में थ्रो कर देते हैं। जब आपने हॉच पॉच में थ्रो कर दिया, आपने कहा ये मेरी सेल्फ इक्विटी 10 लाख रुपए में आज से कॉमन हॉच पॉच में दे रहा हूं अपनी HUF के लिए। मैं HUF कंसिस्टिंग ऑफ माई सेल्फ, माई सन, माई डॉटर, माई वाइफ एंड मे बी माई डॉटर इन लॉ, और मे बी इन द फ्यूचर एंड whosoever is join my family in future, बेनिफिट के लिए 10 लाख रुपए में करता हूं। और आपने बैंक अकाउंट खुलाया और उसमें चेक से पेमेंट वो अलग कर दिया। तो एक तो ये रास्ता हो गया, पर इस रास्ते में बहुत सारी अड़चन है। जो लोग इनकम टैक्स एक्ट के जानकार हैं उन्हें पता है कि अगर आपने अपनी प्रॉपर्टी को कॉमन हॉच पॉच में डाला है तो बहुत सारा उसमें प्रावधान को जो उसकी जो इनकम है वो आपके हाथ में ऐड होती रहेगी। क्लबिंग ऑफ इनकम होती है।
यस,
हाँ, तो क्लबिंग ऑफ इनकम। तो देखिए हर ऐसी समस्या के लिए इन लॉज बड़ा काम आते हैं।
यस,
अपने
एग्जैक्टली,
फादर
गिफ्ट फ्रॉम इन-लॉज, गिफ्ट फ्रॉम इन-लॉज,
क्लबिंग हो जाएगी। हाँ जी,
गिफ्ट फ्रॉम इन-लॉज, गिफ्ट फ्रॉम इन-लॉज।
हाँ, गिफ्ट। ऋषि जी का एक्सपीरियंस जो है वो बता रहा है कि गिफ्ट फ्रॉम इन लॉज कुड बी ए मच सेफर थिंग। तो ये जैसे रंजन जी ने कहा को पार्टनर क्रिएट देयर HUF, वो अपनी HUF खुद नहीं क्रिएट कर रहा, उसके ससुर साहब या उसके साहब या उसकी साली साहिबा उन्होंने कहा ये लो भाई जीजा जी या दामाद जी, ये 10 लो, आज के बाद आपकी और आपकी फैमिली के लिए of you, your wife, your children, we are giving. So a separate corner is created and a separate HUF is created, even if this person is part of another HUF of his own father separately. तो ये अलग से HUF उस तरह क्रिएट हो जाएगी. तो देखिए मैंने एक्सप्लेन कर दिया, डॉक्यूमेंट बहुत ढंग से करनी पड़ती है HUF क्रिएशन की, क्योंकि
गिफ्ट डीड जो जरूरी है उसमें फॉर द बेनिफिट ऑफ,
हाँ जी,
एक्सक्यूज मी, गिफ्ट डीड बहुत जरूरी है कि दैट इज फॉर द बेनिफिट ऑफ फैमिली.
हाँ, ये
That is
बिल्कुल
for the benefit of family.
has to be that gift or that has to for the benefit of the family, and it will be undivided Hindu family. That also we need to write clearly. Who are the current also in my suggestion should also be specified, and who else will be the future members. You can always say that will be determined by Hindu law, and accordingly there will be more and more members can join or leave the HUF as per the Hindu Succession Law or Hindu Succession Act, as may be amended from time to time, something like that. इसलिए मैंने कहा डॉक्यूमेंटेशन बहुत जरूरी है. उसे गिफ्ट डीड कहें या HUF क्रिएशन डीड कहें, whatever you want to say, that of course is your choice. We can go to the next, please.
So next we have, if any property which belongs to the father's name having 4 sons and after death of father, then it will be property of HUF.
देखिए एक प्रॉपर्टी फादर की है, उसके 4 बेटे हैं, तो उससे खाली उसकी डेथ के बाद तो HUF प्रॉपर्टी नहीं बनती है. यही बात हम बहुत देर से समझा रहे हैं. ये तो अभी जैसे अनन्या जी ने आपको इस बार भी समझाया, कभी समझाया, ये तो 4 लड़के और उनके जो फादर है उनकी वाइफ और मान लिया कोई डॉटर्स भी हैं, तो उनमें बराबर बराबर और उनका सेट प्रॉपर्टी होगा. स्टेट सक्सेशन में HUF प्रॉपर्टी है जब एक लीडर जाए कि मेरे पास इट विल बी इनहेरिटेड जो हिंदू फैमिली एंड इट विल बी सो बी माय members of the family. टेस्टामेंट मेरे बाद ये हमारी फैमिली की होंगी तो HUF बन जाएगी. तो दिस HUF gets created as a third. ये तीसरा तरीका है. HUF is created by way of a will. Next, please.
Next question we have from Aruni Mogaji again. He is asking, father wills that his 2 houses will go to his wife and after her death 2 sons will get 1 house each. Later when wife inherits the asset, can she change the distribution?
देखिए ये डिपेंड करता है कि आपने, इसीलिए देखिए अखिलेश ने बताया, अखिलेश जी ने बहुत साफ ये होना चाहिए. तो आप वाइफ क्या राइट छोड़ के आपने सोचना है, मतलब क्या वाइफ ड्यूरिंग हर लाइफ टाइम शी हैज फुल राइट ऑन द प्रॉपर्टी और शी डोंट हैव फुल राइट ऑन द प्रॉपर्टी. मतलब वो बेच सकती है उसे या नहीं बेच सकती है, उसे किराए पर दे सकती है या नहीं दे सकती है उसको, या फिर कहेगी नहीं ये भी लिख दिया आपने कि इन दोनों मकान, एक में ए रहेगा बेटा, एक में बी रहेगा बेटा, लेकिन ओनरशिप वाइफ की रहेगी, वाइफ डिस्पोज ऑफ नहीं कर सकती है. और सपोज वाइफ रीमैरिज कर लिए होगा. बहुत सारे सवाल हैं, एक सवाल नहीं है. आपको सारे सवालों का जवाब कंसीव कर अकॉर्डिंगली उसको अपनी विल में ठीक से लिखना पड़ेगा. इसलिए हमने बताया कि विल में तो बहुत सोच समझ के बनाए. अपने अकाउंटेंट को जरूर कंसल्ट करें विल बनाने से पहले, सलाह लें. उसके बाद अप्रोच ए गुड लॉयर हु इज एबल टू राइट ए गुड विल, और फिर अच्छे से डिस्कस करें आपस में कि ठीक से सही या नहीं. आपके कॉन्फिडेंशियलिटी मेंटेन करना, क्योंकि अगर आपने किया ना वो विल आपने एग्जीक्यूट कर दिया तो बात से ठीक है ना, और जिससे खतरा हो सकता है. तो इसलिए कॉन्फिडेंशियलिटी होना या नहीं होना उसको भी बड़ा ध्यान से देखना जरूरी है. तो मैंने बताया कि 2 मकान हैं, आपके विल में बड़ा लिखिए कि क्या होगा. आपने क्या लिखा उससे डिसाइड होगा कि वो चेंज करती है डिस्ट्रीब्यूशन या नहीं कर सकती है. हम लोग नॉर्मली जो ड्राफ्ट करते हैं हम उसमें वो वाइफ को हमेशा हक देते हैं कि दैट शी कैन चेंज दैट डिस्ट्रीब्यूशन एट एनी टाइम, ताकि ड्यूरिंग हर लाइफ टाइम शी गेट फुल अफेक्शन फ्रॉम बोथ द सन्स. दोनों बच्चों को पता है कि माता जी को लुक आफ्टर करेंगे जब तक इनकी जिंदगी है, तो हमारे को कुछ मिलेगा, नहीं तो ये सारे ही दो के दो दोनों मकान बड़े को दे जाएंगे, छोटे को दे, जो किसी लुक आफ्टर नहीं करेगा दूसरे को दे जाएंगे.
So next question we have from Kawal Ohri ji. He is asking, if daughter refuses to take share, can husband claim from daughter's father's property?
हस्बैंड नहीं है उस प्रॉपर्टी के ऊपर. डॉटर का जो हस्बैंड है उसका कोई लेना देना नहीं है. उसको तो मतलब घुस के बाहर निकल. अगर डॉटर ही मना कर रही है, हाँ देखिए, पर ऐसे केस को हैंडल बड़ा केयरफुली करना होता है कमल जी, क्योंकि ऐसे केस में जब डॉटर मना कर रही है, डॉटर हस्बैंड ने क्लेम किया, तो बहुत चांसेस ये हैं कि अगर ज्यादा डिफरेंस हुई तो वो मैरिज ही नहीं लास्ट करेगी. अगर डॉटर मना कर रही है, हस्बैंड कह रहा नहीं ऐसी कैसी 5 करोड़ की प्रॉपर्टी है तो कैसे छोड़ देगी भाइयों के लिए, तो फिर झगड़ा होगा, और झगड़ा इतना होगा कि वो या तो मैरिज रहेगी या फिर एक्चुअल रियलिटी है. इसीलिए भी करें, बेटियों से बात करके ठीक से करके टेस्टेड सक्सेशन करें. इंटेस्टेड सक्सेशन हैज इट्स ओन बिग प्रॉब्लम्स एक्चुअली. इवन देखिए हमारा जैसा समाज चल रहा है, समाज में ये एज्यूम कि जो भी विल है, विल की फादर ने या नहीं की, लेकिन सारा जाना बेटों के पास है, ऐसा मान लेते हैं बेटे. और जो भी बेटियां उसमें क्लेम करते हैं तो वो बेटियों के साथ रिश्ते तोड़ देते हैं भाई. ऐसा समाज में एकदम आम है. बातचीत तो इसलिए जो अगर आपने अपनी विल ठीक से बनाई है, और सबको पता है फादर की विल थी, इस वजह से डॉटर के पास जा रहा है, चाहे आप उसे इक्वल शेयर ना दें, चाहे उसे 10% ही दें, चाहे 20% की चॉइस है, सबको बराबर दें, या अपनी वैसे दिल का मैंने बताया, सब कंट्रोल का. लेकिन जो भी हो वो सक्सेशन प्लानिंग करके ठीक से विल में लिख के जाएं, ताकि बच्चों में झगड़ा नहीं हो. तो हमने देखा कि बच्चों में बहुत जबरदस्त झगड़ा होता है. थैंक यू.
So next we again from Kawalji. He is asking, after mother has transferred property through testimony instrument to son, and son later does not take care of mother, can mother claim her share from son?
देखिए, ट्रांसफर अगर उन्होंने कर दिया प्रॉपर्टी को, गिफ्ट ही कर, एग्जाम्पल इंस्ट्रूमेंट से गिफ्ट कर दिया, फॉर एग्जाम्पल बेटे के नाम में प्रॉपर्टी अपने जीवन के दौरान ही ट्रांसफर कर दी, उसके बाद अगर मदर को बेटा लुक आफ्टर नहीं करता है तो प्रॉपर्टी तो वापस नहीं ले सकती हैं. लेकिन जैसा मैंने बताया था कि माननीय सुप्रीम कहा है कि मदर फादर को लुक आफ्टर करना बच्चा धर्म है, उसके उसे मेंटेनेंस देनी होगी, और घर से बाहर वो उन्हें नहीं निकाल सकते. ये दूसरा माननीय सुप्रीम कोर्ट ने दिया है. लेकिन अगर मान लिया बहला फुसला के उसने मदर से प्रॉपर्टी अपने नाम में ट्रांसफर करा ली, ऐसा मदर आरोप लगाती है, तो ये पर्दा नशीस के लिए सब समझिए हमारे समाज में एक और कानून है जो कहीं लिखा है कहीं नहीं लिखा है, दैट इज ए कोर्ट मेड लॉ, अकॉर्डिंग टू विच, और उसको एक तरीके से, क्योंकि एक्चुअल स्थिति ऐसी हमारे में लेडीज की कि उनको बहला फुसला के लोग साइन करा लेते हैं, उन्हें बताते नहीं भी क्या साइन कर रहे हैं वो. एंड इन लार्ज नंबर ऑफ केसेस दे माइट नॉट बी इवन दैट वेल रेड, इतनी पढ़ी लिखी भी नहीं होती, उन्हें समझ नहीं आते क्या साइन करा लिया उन्होंने, बताते कुछ और है, साइन कुछ और कराते हैं. अगर ऐसी तो उस केस में तो प्रूव पड़ेगा कि माँ ने अपने होशो हवास में अपनी फ्री विल से मेरे को प्रॉपर्टी ट्रांसफर की थी. और मदर अगर कोर्ट में कहेंगी समझाया नहीं, कागज पे खाली दस्तखत करा लिए, मुझे रजिस्टर कि मैंने आपके नाम है, आप साइन कर दो, और इसने मेरी प्रॉपर्टी अपने नाम में ट्रांसफर करा ली, अगर उन्होंने ऐसा बयान दिया तो फिर आप समझिए बहुत मुश्किल हो जाएगी. तो इसीलिए आपको ये ताकीद की है कि डोंट टेक मदर बिग, बट ये डिस्प्यूट होगी, बरसों तक चलेगी. अल्टीमेटली कोर्ट डिसाइड करे कि फैक्ट्स कैसे, तो फैक्ट्स को सब ठीक से देखना जरूरी है. इसीलिए बड़ा इम्पोर्टेंट है, जरूरी है कि अपनी वाइफ को, खासतौर पे जो मदर है, किसी की वाइफ तो थी, ठीक से एजुकेट करें, बताएं क्या है, क्या करना है, क्या नहीं करना है, और क्या आंख मूंद के करना नहीं करने हैं, ये सारी चीजें जागृत करना हम चार्ट भाइयों का भी हाथ है, क्योंकि हम हैं, पूरी फैमिली मिलती है, जब साइन करती हैं अपनी इनकम टैक्स रिटर्न वगैरह आती है, तो ये अक्सर 90% लेडीज को ये पता ही नहीं होता वो ओन क्या करती हैं। ज्यादातर वो यही कहती है जब इनकम टैक्स की रेट बढ़ती है, अपनी हस्बैंड को पता है, और हस्बैंड चला गया उसको पता है, इसलिए जरूरी अपनी communicate रखें। We'll go to the next, please. It is already seen. Go on.
Next
You can
question.
take one or two more.
Yeah. Next question we have from Geeta Gupta. He's asking, will the 2005 amendment apply to a daughter married before the commencement of Hindu Succession Amendment Act of 2005?
This applies to all daughters, they are married or not married. Are married before 2005 also is entitled to share in the HUF property without any doubt, provided her father has not expired before the 2005 date. मैंने बताया 2004 की डेट से पहले अगर फादर की डेथ हो गई तो फिर ये कानून काम नहीं आएगा आपके, लेकिन उसके अगर ये फादर इज ऑन दैट डेट और डेथ इज देयर आफ्टर, फिर जरूर काम आएगा आपके।
So last question we again from Geeta Gupta ji. He's asking, a Hindu father of his son and two daughters get property from his mother. Before his death, his son, to whom he gives all the property, also has a son. Is the property HUF in the hands of grandson?
His son also gets property from his mother. The course getting property from mother, it doesn't become a HUF just because you got property mother. Another clearly, while she bequeath that property or she do succession of that property through a testamentary document, says ये जो property है, this will be property of for the benefit of the family of my son. ठीक है ना, अगर मदर ने कहा कि मेरी फैमिली के लिए है तो फिर बेटी, फिर बेटे का सन, उसकी दोनों डॉटर, वो सब एंटाइटल हो जाएंगे। कुछ नहीं कहा तो फिर वो मैंने बताया कि आज जो कानून है उसके हिसाब से वो अगर बेटे को देकर गई हैं और उन्होंने फैमिली का नहीं जिक्र किया, अपनी प्रॉपर्टी की ये लेगी, इट विल बी सेल्फ एक्वायर्ड प्रॉपर्टी एज फार एज द सन इज कंसर्न, and the son and the daughters will claim on the property.
Thank you, sir. That's all the questions we have. And once again, thank you and your team, Ananya ji and Akhilesh ji, for sharing such an in-depth knowledge with us. I would also like to thank Shashikant Chadda ji for being on the panel with us. And thank you all the viewers for attending this webinar.
Thank you.
Thank you.
Thank you, Shashi. Thank you to Bhavya and to all the listeners. Thanks to Advocate, thanks to Illegitimate, and thanks to Chavi and Astha for supporting our team. Thank you so much.
Thank you so much, sir.
Thank you, Sunil Bhai. Thank you. And thanks to Raj Chawla ji.